Please.
You do solemnly swear the testimony you're about to give in this action is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, please be seated.
Where's the letter with the offering to go to school, kindergarten? You've submitted an email to the court that you've attached to your motion to change custody, and you've alleged that Michael did not tell you of Devin's first day of graduation from kindergarten for 2014.
Without seeing the email, I believe I did send something like that, yes.
And the graduation was in the end of May 2014?
I don't know the exact date of the graduation because Michael never told me.
Okay.
I didn't have the kids for, I think it was 14 days or 10 days, so he was getting all the notices and he didn't tell me. He did tell me that they were ordering graduation T-shirts,
okay. So
but he never told me the actual date of the graduation.
So you received emails from Mike at Hanley34@gmail?
Yes.
Okay. And in fact, on May 7th at 11:30, well in advance of the school graduation, he sent you the flyer, including a link below for you to view about the graduation ceremony.
Wait
a minute, please.
Okay.
With a link for you to review the information about the graduation. Correct or incorrect?
I never looked at the link, actually.
Okay, I didn't ask you that question. I asked you if he forwarded you the link on May 7th. That's a yes or a no.
I would need to see the email so I can be
sure.
sure.
Refresh your recollection, Your Honor.
Is this an exhibit?
I'm going to object to its admission, but she can refresh her recollection with it, I guess.
Does that refresh your recollection that Michael sent you the link in advance of the graduation information at school?
Yes, however, this...
Wait a minute.
It's not an exhibit.
And did you respond after this meeting? You didn't respond after this asking for further information about the graduation, did you?
I don't know. I couldn't answer that, to be honest with you, without looking in my email box because we had so many emails between he and I. However, when I look at this, it says
Your
to
Honor,
where...
there's no question pending.
Yeah, you can't testify the contents, ma'am.
Okay.
Doesn't say anything about a graduation.
But,
Your Honor,
yes.
I'm going to object.
I have a problem with this, Your Honor. We're going to have a problem all
You know what?
afternoon. I want to tell you
I have a bang-up idea. Well, why don't you both stipulate to its admission, and then you can ask her about the contents when you get her on redirect.
But look at the uneven playing field I'm
Your Honor,
on.
may I
That
object?
all of my stuff she has to review, but her stuff I don't get to review. Even just during this month, she didn't send me 20 emails that say they weren't admitted into evidence, but please be ready for them. So now I got to sit back and watch her try to refresh the recollection of a witness with a document that talks about graduation shirts.
Your Honor, may I object because...
What do I do the rest of it? Do I let her evidence in, which means the discovery rules are just violated, or do I protect my client and find a way to get the court to allow me to...
With her recollection refreshed, you can get her on redirect and clarify.
For the record, because Your
No,
Honor, if
for
I
the
don't make
record, ask the
objections,
next.
they're
For
forever
the
waived.
record, ask the next question. We're finishing at noon.
But if Neil's allowed to
Counsel,
testify for her...
refresh. We're
gonna
done.
testify for
We're
her,
finishing at noon.
I'm cross-examining her on his examination that took about 3 hours of her.
I understand that.
Thank you, Your Honor. Okay. So you did not write Michael until after the graduation, and then you complained that you didn't have information, correct?
I can't remember without looking at all my emails.
And
I do, though, remember I had sent some emails to him in some periods, which I'm sure he hasn't shown to you, Ms. Vaccarino.
object to speculation and goes beyond the scope of my question.
Sustained.
That was sustained, Your Honor?
Yes.
Okay. On July 19, 2013, prior to that date, had you told Michael or the court that you were in a methadone program?
I was never in a methadone program, Ms. Vaccarino. That is absolutely incorrect. So you cannot say that I said I was in a methadone program when I never was, and I never told anybody that. That is incorrect. As a matter of fact, on the record, we had stated in front of the judge, Mr. Sachs and me, that I was under pain management. And that I was being treated by a doctor. It's in there, Ms. Vaccarino. You can look for it where Mr. Sachs said it.
Okay. If you, the judge says in your own page 11 of your trial brief filed right before this trial at 11:08:00, did you type these in or did someone type these in for you?
I did not type these in.
Who typed these transcripts, these unofficial transcripts for you? Just trying to verify the accuracy.
Crystal?
All of them?
I believe so, yes.
Okay. And did you go back and verify the accuracy of these?
Ms. Vaccarino?
I'm just asking a question.
Yes, I did. Please
Okay.
read.
At 11:08 it says, the judge says, not me, you know, Ms. Vaccarino, in another case where we had methadone use and there was a question about levels that show up, what I'd asked for was the supervising doctor to provide a letter that the drug levels were consistent with the
Do you
treatment
know
program.
which judge is this, Judge Nathan?
Yes.
Okay.
And and you said, well, thank you, it's used for pain management as well, not for just. So right there, you were admitting you're on methadone, but it's for pain management, correct?
That's exactly what I admitted. It was for pain management,
But
correct?
you just told me you were not. You just swore up and down that you were not on methadone.
I was not on a
Objection,
methadone
Ms.
program.
Fairchild.
You know what?
testimony?
Sustained. Ms. Vaccarino, that is not what this witness said.
Thank you, Your Honor. Store the question. Explain to the court, you were on methadone, which is different, you believe, than a methadone program. Is that your testimony under oath?
Yes, I do.
Okay, where did you learn your information about being on methadone or in a methadone program first?
Research on the internet and speaking to my doctor.
Which doctor was it that you were speaking to?
Well, the original doctor that I'd spoken to was Dr. Robertson, who is now deceased.
Okay.
Dr. Robertson, who is now deceased, he was a pain management doctor. Michael was very familiar with him. He's the godfather to our son. He was very well trained. I actually used to work in his office a long time ago. And then I learned some of it from him, and he explained the differences to me then, because he would actually put. And then
I
Dr.
just want to
Custodial.
clarify foundation-wise. This was in 2013 you learned this?
No, that was back in 2005 when I worked for him is when he explained the difference to me.
Have you been on methadone prior to July of 2013?
No. Oh, well,
Prior to-
April of 2013, I believe, is when I went on it, and it was by my choice, not by the doctors, Miss Vaccarino.
Was that with Desert Pain Management?
Yes.
You're aware that I asked the judge to take judicial notice that Dr. Cathura, that you've disclosed in your
I'm going to object to this. She's going to.
Object to it.
I'm going to object to
What's the
it.
objection?
First, it wasn't produced in discovery. Second, the doctor's not here under cross-examination, so it's hearsay. Third, the fact that a doctor gets disciplined later doesn't have anything to do with this. Second, there's a McMonigal here. The only reason why she's opened this up is because she never proved she was on drugs
I'm gonna
before,
object
and now
to
she's
the
trying to
talking
prove it now,
objection.
and McMonigal bars evidence of that. So I didn't produce in my initial exhibits anything about what the trial was about, but now she's trying to go back and retry a case she had in front of Judge Nathan.
There's plenty of things, Ms. Vaccarino, that happen in a trial that the lawyers think is going to be helpful to the court. Okay? And sometimes we just get so far off the rails that we waste the judge's time. As a practical matter, I'm not revisiting any of these issues. We're done with that. If you think there is a present drug problem that the plaintiff has, feel free to inquire about that.
For the record, Your Honor, you said already, and now you put us outside, but you've told us on December 22nd, not having heard substantial evidence, that you're going to find that she's met the substantial change of circumstance prong under Ellis by virtue of the fact that she's just going to simply testify about her current and past drug usage, and these are recent issues. I'm not rehashing. You even said, and I have quotes, in April, when you were trying to get them to mediate, and then
Yes,
in
but
July that she would have to have an epiphany and have
I don't
redemption.
want to go
You're not allowing
off
me
the
to defend the
rails
substantial.
into an indictment of somebody who's not present.
I'm not going off the rails. I'm asking her what she's, because her own brief, Your Honor, in December 17 of 13, I warned Judge Nathan I was concerned with where she was getting her drugs and could be under police investigation.
None of that's
And then
evidence
in
either.
March-
What she warns a judge is not evidence here. She's trying to prove it. Now she's doing an argument on an
She
objection.
was shopping
It's
for
not
her
improper.
drugs at a place that was like a
That's
club.
argument, Your Honor.
An argument. Let me make it
Don't you
clear
wanna
to you, Ms.
understand what she
Vaccarino.
did and where she's
Let
been?
me-
Objection. She
I
can't
said-
tell you what she
Both
did.
of you sit down. Both of you. Let me make this perfectly clear where I'm coming from. You are a patient who's not a doctor. You find a doctor, you don't know whether they're being investigated, you don't know. But the doctor prescribes something for you. Now, it later turns out that that doctor might have been disciplined by the medical board. Maybe.
Here, let me
But
tie it together.
that does not and will not in this court provide any evidence that's of assistance to this court that this particular plaintiff did anything more than follow a doctor's advice. If the doctor gave bad advice, that's not her fault. So,
That's not where I'm
let's
going.
move on. On. Get off this dime, counsel.
Your Honor, we were going to renew our oral motion that you said you would defer on to have someone credible that would provide you with substantial evidence about her past, current, and even on December 22nd, it's an oral motion, she admitted that she took some hydrocodone again when her daughter was born in October. I would like you to allow me leeway to connect the dots.
Ms. Vaccarino,
to
have
connect
you-
the dots for you to show that she hasn't met your substantial
Ms.
change
Vaccarino,
prong.
Ms. Vaccarino,
You're not allowing my
have you ever
client to
had
do a
surgery?
case.
Have you ever
I
had...
don't want to talk about my
No.
life or your
All
life.
right,
We
then.
need to talk about hers.
But-
Hers. Her journey.
It's
not
almost
mine.
comical what happens when
This
people
isn't
have
funny.
surgery. Sit down, because I'm going to finish this point without interruption. It is very comical what happens when somebody has surgery, even minor day surgery. The next thing you know, you're sent by the doctor before the surgery or after the surgery to fill a prescription for hydrocodone. And they don't give you like 5 pills, they give you like 30. Now, most people I know, and I don't know whether this applies to the plaintiff, but most people I know, they take about, over the time, maybe 7 of them. And then the rest goes into a back shelf, ultimately for disposal. Now, if the plaintiff had a C-section, a doctor would almost be committing malpractice not to prescribe some kind of pain medication. I find all of this almost offensive. So, you want to continue on it? Keep offending me.
The only thing I
Well,
want to
that
add
is
to
And
it,
that's why common
part
sense...
of the
word I want to add to it
Ms.
is
Vaccarino,
discovery.
You're
this is
not
my...
allowed to bring in your own common sense or
Oh, yes, I am.
Your Honor, you're not allowed to say any doctor with her history has to be careful and
Let me
understand
just
her
say,
history.
let me just say...
That's what I'm saying to you.
Okay,
And I
but
would
I
like
am
you to have
perceiving-
professional advice on
Okay,
it.
counsel, I am perceiving this as a waste of court time. Keep going.
You allowed her to say,
Keep going.
okay. You recall,
Keep wasting my time.
Your Honor, I find your comments to me to be improper in the context that I'm only trying to impeach her claims about you already having found she made a substantial change case.
I'm sitting
if I
here
may-
listening to the other side testify, and I've had it.
I agree.
I'm not, Your
there's
Honor.
only one
I'm
thing
just
I want to add to
commenting
this.
on you saying
I'd like to be
I'm upsetting you.
I'd like to be heard for 2 minutes.
offending you.
No, not even 2 minutes. 30 seconds.
Your Honor, I'd like to go file a writ to ask for the standard on this case
Hold on for a
because
second.
substantial change doesn't mean you just said I'm done and I don't have to explain the method.
Hasn't made a ruling yet. Okay.
She did.
The
You
judge
already
can
told
be.
us.
Judge can have her
I'll let
mind
him
changed
yell
anytime.
over me.
There's only one thing I
done.
want to say here, and that is, during the 2-year period this case was pending in front of Judge Nathan, she could have done discovery. She could have examined and cross-examined doctors. She could have used the prescriptions. During this case, knowing that we had this motion filed, she could have done discovery for the last several months. We could have had a doctor or medical testimony here, paid for by her client or mine or whatever, testify about whether the prescriptions that this lady had were consistent or not consistent or whatever. She can't wait till after discovery without producing a piece of evidence and start yanking stuff out of her briefcase to convince you that something a doctor prescribed for her was or was not appropriate based upon a history that she hasn't produced in discovery. Thank you.
Ask your next question, Ms.
I'm
Vaccarino.
going to, just if you're going to deny, I'm going to renew our motion that it be fully evaluated, because I don't think you, Neil, or even Amy, because she never provided the HIPAA release.
Denied. Now, move on.
You're not interested in having the history. Isn't it true that you were ordered by Judge Giuliani to provide letters from doctors in November 2012? The judge told you you have to provide letter from, she said, I don't know who your doctors are,
We
correct?
admitted them as exhibits in the last,
Your Honor, he doesn't need to speak when I'm...
they're already admitted in evidence.
No, Mr. Mullins, you either have an objection, or you sit there silently and listen and
I won't say
plan your
anything.
redirect. It's almost 10.
Do you recall, it's at page 8 of your trial brief that was
Yes.
recently filed?
Yes, she did.
Okay, and Judge Nathan said,
Wasn't Judge Nathan. Ms.
I'm
Vaccarino.
sorry, Judge Giuliani said, you had come back with a dirty drug test on November 26th.
It was never a dirty drug test, Ms.
Okay,
Vaccarino. That's your verbiage. The judge never said it was dirty. The judge said that I
Your Honor, if I
had...
may restate the question instead of having Amy.
Tell you what, just answer no.
No.
You came back with a drug test that said you had Adderall and narcotics in your system, correct?
It said I had Adderall and opiates in my system, which I had disclosed to ATI, my prescriptions.
Wait, Your
I
Honor, if I can't let her run on and on. So after you asked her my question, I asked. So you said it had...
You know
had-
what, ma'am? I think Mr. Mullins is going to be very well prepared for your redirect. Just
Okay.
answer yes or no.
Okay.
So you had Adderall and pain pills, correct?
Yes.
And you were instructed on November 26, 2012, and there were 2 court orders to sign a HIPAA release so we could see your records from who prescribed the Adderall and the pain medication, correct?
Yes.
Okay. You never provided the name of the doctor that prescribed the Adderall to Michael or my office, correct?
That's not true, Ms. Vaccarino,
Okay, so
no.
who is the doctor that prescribed your Adderall?
Dr. Jacobs, Lauren Jacobs. You were given this in July 19th of 2013.
Okay, so you waited till July, 8 months after the
You
order
never
was
asked
entered.
prior
Is
to
that correct,
that.
Amy?
Ms. Vaccarino, I never
Is that
waited.
correct, or-
I supplied it.
Your Honor, I can't
Oh.
unless she just answers my question.
Oh.
We're not going
I
to have a good
said,
record.
Mr. Mullins has tried a case or two here and there. He's going to be taking notes on all the things he's going to do to endeavor to rehabilitate, however you have to answer Ms. Vaccarino.
No, that is incorrect. I didn't wait 8 months to supply those to you, Ms.
You
Vaccarino.
told me on July 19th you told us the name of Dr. Loring Jacobs. Is that true or false testimony?
Well, that's true. I told
Okay.
you in open court,
Thank you.
but...
Your Honor,
She asked for a yes or no answer, Amy.
Okay.
You're going to give her a yes or no answer?
Okay.
The judge has told you, and I've told you. My pen's going to be going. If you don't get an opportunity to answer, I can ask you a question if I deem it relevant, and you can answer. Yes or no if it calls for yes or no.
Okay.
Okay?
Okay.
Thank you.
and Judge Giuliani told you, like I do for all my other litigants, she wanted whoever your doctors are to have a letter from them stating that these prescriptions are current with your levels.
Yes.
Did you understand what the judge meant when she made that order?
Yes, I did. And I did supply.
Okay, thank you. You understood. And in fact, all you've provided was a letter from a nurse practitioner from Desert Pain Management that said they were prescribing you oxycodone, correct?
That's
Yes or
incorrect. No, I did not. It was
Okay.
from the doctor as well, too, Miss Vaccarino.
And they said they're aware of Adderall, but they don't prescribe it, correct?
I would have to look at the letters to be exact, but they said that they actually verified my prescription. The nurse practitioner said they had verified my prescription because Mr. Jacobs was out of town during that time.
If I may approach with Exhibit H, do you have the exhibits there or no?
Is that admitted?
I don't have hers. I don't have her book.
It's not up there? Do you have it? Okay.
I forget what if anything, you stipulated to Mr. Mullins.
Are we talking about is Exhibit H the same letter she attached to the court?
It's one of them. It's not both of them.
Ma'am, there's no
It's a
question.
letter dated November 30th, 2012 from Maria R. Is it Berlan?
Yeah, but there's another one as well, Ms. Vaccarino.
Okay.
It's right there. It's okay. It's
Exhibit
fair.
H.
It's fair. It's in our
Stipulate
exhibit,
to
too.
the admi-
Okay.
yes,
Yeah, because I have it in mine, too. That's
Sorry,
fine.
we did stipulate to admission of.
We have both of them, correct, Neil? The one from the
Yes,
doctor and
as
the
long
one
as
from-
both of them come in, Patricia. I'm not
I don't know what other
stipulating.
one you're talking
They're in my exhibits right there.
So
Ms.
what exhibit
Vaccarino?
is yours of this one?
It's
There's
the, it's
H and there's
the, mine
I.
is a pleading,
H
okay?
and I.
Mine is a pleading, and mine's a, and so it wouldn't be objected to anyway. And it's a
They would
pleading where the
because
judge
they
asks
still-
for letters, and there's two letters there.
There's H and there's I. Are we agreeing on that?
H and I. Let me look at
That's in
her.
her book.
Where's her exhibit? H
This
and
is
I.
I. And then H is right here.
Is that the same two as what's here?
No, they're different.
Writing this letter in response.
You want to read stipulate to the admission of H and I because it's the same letters they
I can't
have.
read. I can't read the
Can't read the dates on hers. We can get this easy, though. Patricia, will you look at mine, too, at the same time? Because then they can all come in.
Well, you have a whole pleading.
No, not a whole thing. It's number, it's the pleading dated 12/4/2012 that the judge read at the last hearing, and we have it marked as Exhibit 71. And if you agree to those two, which may even be the same as your two, in addition to your two, I'll let yours in too. Do you see that?
Give me the number.
71,
And
both of our letters are in the same exhibit. It's the last 2 pages of that. I'll show you. This page. And then there's 2 attached to it.
I mean, I would stipulate to 71 as long as you add in the letter that I wrote in April asking them to help me follow up because the doctor wasn't answering.
What?
I have no objection.
Okay.
Okay,
So
so
I'll mark
what's
that
in?
separately.
Please make
So
sure
we're
my clerk
stipulating to
knows.
71 and G and H, and he's stipulating to allow in one letter I wrote in April to Denise that asked.
E and H or H and I?
I'm sorry, you're right, Your Honor. H and I.
H and I.
Sorry, Your Honor. H and I.
And 71, let me look at 71.
Well, the issue on 71 is the last 3 pages of it initially.
No, just H, I, and 71. Ask your next question, counsel.
Okay, in this letter from December 3rd to 12, it says the doctor's name and Maria's name. Is that Maria's signature for the doctor?
No, it's not. As you can see, it says Dr. DR right in the front before the signature.
And
She was his licensed nurse practitioner.
why didn't
so-
you get, who was prescribing the Adderall during this period?
Dr. Jacobs.
And why didn't you get a letter from him?
He was out of town. It was during the Thanksgiving weekend.
And through this date, you still have not provided a letter from Dr. Jacobs showing that the level of Adderall in your system was, well, first of all, you haven't provided a letter from Jacobs saying he prescribes it, correct?
No, because
Another thing is, isn't it true that after that you sent over the release that the Judge Pomeranz ordered in March of 2014, in the end of March 2014, through Denise Gentile to my office?
she actually never ordered for me to sign a new HIPAA release, Ms. Vaccarino. She confirmed you had it, but we went ahead and executed one for you because you asked for it.
You were ordered to execute a release by the...
No, I was not.
Oh, gosh.
No, I was not. I have the actual order.
You did, in fact, and after
Because
Judge
you asked
Pomeroy
for
first
it.
heard this case, Your Honor, she's talking over me.
She's allowed to
Let her
finish the
finish
question.
the question.
You, in fact, signed another HIPAA release, and you disclosed one doctor in March of 2014, the end of March, being Dr. Kathura as your doctor, correct?
The only doctor I'd seen for the prior 6 months,
Wait.
because Ms. Pomerantz was very specific and
Your
said
Honor,
you
if
can
I
only
may,
go back 6
she
months.
keeps- You only listed one doctor. I'm going to move to strike and say yes or no.
I'm going to object to this because there's a court order involved. She
Your
did what
Honor,
Your Honor
Rule
ordered.
been sustained.
You listed, through Denise, in your own Exhibit 71, Dr. Kathura as your only doctor for a 6-month period, March and beyond, and past.
From September 25th to September 25th of 2013 to March 25th of 2013, whatever the HIPAA release says. That was my only doctor at that time.
Well, you filed paperwork in court in November when you were trying to set aside this order saying, from the same Desert Pain Management, saying that you were no longer on any narcotics and you were only doing massage and chiropractic.
That's incorrect.
In the
What I
fall?
said is I was on Tramadol Ultram, which was a non-narcotic, which I was still receiving from Mr. Katura's office at that time.
And then you came into court on December 17th and told the court you were no longer on methadone, but you were back on hydrocodone.
I had actually been
Wait
on
a minute. Did you tell the court, yes or no, that you were on December 17th, Judge Nathan, did you tell Judge Nathan in open court you were on hydrocodone? You corrected me. It's in your transcript.
It is in the transcript.
Is that
and
yes or no? Did you tell
I-
Judge Nathan that?
I can't answer that with a yes or a no, Ms.
And answer it no.
No.
You're going to answer it yes or no.
No.
One of the two.
What did you report to the court, about your drug usage on December 17th, 2013 in open court?
That I was actually on hydrocodone due to dental work that was going on at the time, which my next drug test, which I had taken in March of 2014, which was 90 days, that went back to December 25th of 2013, showed absolutely nothing in my system, Ms. Vaccarino.
You were pregnant at that time, correct?
No, I was not.
I'm pregnant.
I didn't find out I was pregnant until February of 2014. I got pregnant on New Year's Eve or January 1st or 3rd. You don't find out immediately. I had to miss my first period before I found out I was pregnant. So pregnancy had nothing to do with me taking medication
You've
or
never
not.
provided a letter from the doctor that tells any judge that sat on this case, Judge Giuliani, Nathan, or Pomerantz, that your Adderall levels found in your system on November 12 were consistent with the drug test results. Is that yes or no?
I'm going to have to say no to you because I did supply a letter.
Look it. You're a very intelligent person. You don't have to say, I'm going to say yes or no.
In fact-
Yes or no. One syllable.
Okay.
In fact,
If she wants an explanation, she'll ask for it. She's a great lawyer.
you were ordered to be drug tested in late August 2012, correct?
Excuse me? Can you rephrase that?
When did you go submit to the first drug test? Wasn't it late August 2012?
It was on
When it came
August,
back?
actually it was August 15th of 2012.
And you swore to the court you were on nothing else but pain medication. Wait, you told Judge Giuliani at that hearing that you did not mention Adderall. You only said you were on pain medication.
That is not true. I actually watched the video hearing of that hearing, and I had actually disclosed the Adderall, I believe, at that
Are
hearing.
you sure about that?
I'm pretty sure I did. I could be stand corrected, but I'm pretty sure I watched that hearing, and I said in open court, because it was Mr. Liker,
Your Honor,
you
she's
weren't
answered the
present.
question. She's pretty sure.
You weren't present. It was Mr. Liker.
I was present when the first-
You know, I have an objection on relevancy for some of this because
Well, you
that
said-
was all tried in July 19th.
So the objection
So-
is now late.
So now we're going to talk about stuff in 2012.
The relevance is, Your Honor, substantial change prong. If you're only looking to the parents'
Well, I
change in
think
their
then
life.
you've allowed the witness to meet it.
Oh, you
Frankly,
think so?
in your cross-examination,
Think so,
you made the substantial change argument.
I'm not even
for
sure there's a-
Oh,
Mr.
without her
Mullins.
even having to provide the letter or affirmation.
Ms.
or that.
She didn't prove it
Vaccarino,
then.
you actually
She didn't prove it then or now.
You actually made Mr. Mullins' argument on substantial change of circumstance.
Oh,
Thank
you
you.
let- really?
You've saved Mr. Mullins a whole lot of time.
Well, thank you then. Maybe we should just close the case now, and you make your findings, and then we can file our appeal. Because, Your
No,
Honor, I am shocked.
because I'm
Honestly, I
telling
don't
you,
mean any disrespect.
you
but-
said, I had said that I would consider a cessation of drug use to be a substantial change of circumstances. Do you recall me saying that? Yes or no?
You said you're going to find that it is a substantial
Okay.
change. But
and
you have to
guess
have
what?
substantial evidence.
I
in
got
your
a
record.
March of 2014 drug test that's negative. Wow, that's a big change of circumstances.
Think so? Substantial, with one drug test. That makes
One drug
her-
test
that
and
makes
no
the
other drug
children's
tests that
welfare
indicate
enhanced.
use other than normal prescribed use. You
don't
wanna
know
take-
yet. You have
Do you
no
want to
testimony.
take me up on appeal on that? Fine, because that is not going to be my only basis for finding
I
a
know,
change
you
of
already
circumstances.
got a bunch-
So why don't you finish this test? Let's wrap this up. You can call your client, and then I can make my decision. Keep going. Ask your next question.
So, during what period of time were you allegedly on no pain medication or Adderall in 2013 and early 2014?
Okay. So 2013, I did not take any Adderall. 2014, I have not taken any Adderall. 2015, I have not taken any Adderall. I actually picked up my last prescription for Adderall in November of 2012, and I made the decision not to take it any further because I didn't like the way it was working with me. My drug tests are indicative of that, Ms. Vaccarino. You guys have also had multiple months since July of this year on your own court order to drug test me. You haven't. So it's obvious.
Correct?
Oh, you had it after I got pregnant starting in
She's
October.
lecturing me now, her closing argument. I think she's answering.
You know, you're getting kind of argumentative.
Yeah, I understand. But
Don't,
So
that means
there's no
don't.
letter about it.
When she said that, you know, that means don't.
as far as pain medication...
You're done.
Okay. You don't want me to answer?
No,
regard-
if she wants
okay.
another one, when she says you're done, you're done.
Okay.
So
Wait,
you so pain medication, for a brief period, you were trying some tramadol and some massage, correct?
I still take the tramadol, Miss Vaccarino, which is a non-narcotic. I have been. The only time I was on hydrocodone.
So you've used pain medication and tramadol on and off since we were in court July 19, 2013,
I'm
correct?
going to have to say no.
No?
You're not allowing me to explain.
Okay, so you used it in December 2013, you were on hydrocodone, correct?
For
Yes or
approximately
no?
1 week. Yes,
Okay.
1 week.
But you haven't provided the dental records to show the court exactly, just your testimony so far.
I had the prescription in open court, and ATI verified that
my
prescription.
question, I'll move to strike. My question...
Overruled.
Okay, my question is, please answer. Did you ever provide your attorney to provide to us in the court evidence that your testimony about taking hydrocodone for 1 week is true? Yes or no?
You've never asked for it, no.
Okay. And
But I
tell
did
me-
give ATI.
Stop.
that. Okay.
After you finish your answer, stop. When she starts talking, you stop.
Okay.
If she interrupts you, I'll protect you, I promise.
And
Sorry.
then you're saying that the whole time you were pregnant, you took no pain medication or Adderall the whole time?
I haven't taken Adderall since November of 2012. I explained in the last testimony, my doctor, it was like 2 months before
You've
the
answered
end of my...
question. Let's talk about the pain medication for 2014. During your pregnancy, did you take any pain medication prior to the birth of your daughter?
I did, yes.
How often did you take the pain medication? I'm sorry, let me withdraw that. When did you first start to take pain medication during your pregnancy?
At the very end of June of 2014 until the birth of her due to the excess weight that I was carrying, and she was in distress.
And the birth was in October?
September.
September? What's
24th.
Okay. And you also testified, I think, on December 22nd that you took, who prescribed the pain medication for you?
My OBGYN, it was a very low dose of
Tell me who the
hydrocodone.
OBGYN is, please.
Oh gosh, I just totally blanked on his name. Bartholomew, Dr. Bartholomew.
And you haven't provided to the court any, or your attorney, because you produced 600 pages of documents. Nowhere in there have you have any of Bartholomew documents, correct?
We supplied actually my prescription records.
Did you provide any records from Dr. Bartholomew?
No, I didn't.
Okay. And is he the one who also prescribed the medication? What is the pain medication he prescribed?
Hydrocodone,
What milligram?
7.5 milligram.
And you said upon birth or during birth you had to take pain meds?
After I had my 4th C-section, my tubes tied, and a hysteroscopy, and
And that all
some other
occurred
stuff.
September 24th?
Yes.
Okay. How long did it
September or
take?
December?
September.
That all occurred in September?
Yes.
How long were you on paid medication from September through?
I got one prescription filled. Well, actually, let me correct that. He filled one prescription for me for Percocet, which I was breastfeeding, and I was not comfortable taking that and breastfeeding my daughter. So I asked him to reduce it down to the hydrocodone, which the 7.5 milligrams. He wrote me one script of it, and I took it for maybe 10 days.
Okay.
And I still have the bottle at home with 3/4 of the pills in
Okay,
it.
so during your pregnancy and since then, you've been able to manage your pain pretty much without medication the last year, correct?
I've been taking tramadol.
And 3 times during this last year, you took hydrocodone. Between December of 13 and January of 2015, correct? About 14 months? 3 times?
Well, I wouldn't say 3 times. I
Tell me
mean,
how many, so the court's clear on this.
I
Since
took.
December 13.
Okay.
How many
December
times have you
13, I
taken-
Both
took.
talk over each other. When
Understood.
she's talking, wait.
Okay.
Thank you.
December of 13, I took it for a week when I was having the dental work, which, by the way, that was prescribed. Okay.
You know what, Your Honor, I'm going to
question.
withdraw the question because she's already testified to it, and I'll save it for summation. When did you stop seeing Dr. Cthulhu?
Oh, geez, I think it was January of 2014. January of 2014.
Why?
I didn't need any pain medication. I was working on tramadol. I was doing okay. And
Who's
then
prescribed the tramadol?
he actually wrote me a 3-month script of it, I believe.
Okay, well, he didn't write that in the letter we just submitted that you were...
That letter was from 2012. This was in 2014, Miss Vaccarino. So why would he...
December of 13.
What letter of December of 13 did he write? There was no letter of December of 13.
Okay, did he prescribe the tramadol?
Yes.
Okay. And weren't you aware that he...
He wasn't indicted until March of 2014, I believe.
You stopped seeing him in January?
2 months before, yes.
And you said,
Ms. Vaccarino, I really hadn't
Mike
been...
asked you before you went to mediation in April of 2014 if you could please provide Dr. Cthulhu's medical records because my office was not able to get a response from Dr. Cthulhu. Do you remember that email?
I do,
It's
yes.
attached to your motion
Yes,
to change custody.
yes.
And you ignored his request, correct?
That's incorrect. I did not ignore it. I actually
What did you
emailed him back and told him I had signed the release and it had been supplied to you as ordered by this court. And I was actually unable to obtain the records myself because when his office got shut down, there really wasn't anybody to go get the records from.
You can go through the case, this board of suspension. You can make calls, and you can get the state has to hand over a patient's.
I was not unaware.
Isn't that true?
I don't know. I'm unaware
So
of
you
that.
concede that as of the date you signed a letter through your attorney, March 27, 14, neither you nor my office would have been able, according to you, to get the records from Dr. Cthulhu that Judge Pomeranz ordered. Is that your testimony?
I would say yes.
So through today, if you have nothing to hide, why wouldn't you want to get those records to show what's in Dr.
I'm going to object to this line because we produced her entire prescription history in the record.
Sustained.
Your Honor, the prescription history isn't the same.
That's what
as
I've
the
already
doctor.
ruled.
Okay. We wrote your attorney in April of 2014, and Denise passed that letter on to you asking for you to assist us in getting the medical records.
I would have to see that. I don't know.
Can you tell the court, you had told Michael in August of 2013, after the July 19 trial date, that you believe there was a right of first refusal for care, correct, of the children?
Me and Michael, we have not been speaking. That would only be in writing and
You
emails.
text him and told him there's a right of first refusal?
I would have to actually see that.
Hey, you said,
Without the emails, I mean,
You know, it's yes, no, or I don't recall.
I don't recall.
isn't it true that Michael originally offered you to take the children for 5 days while he would be in Spain in October of 2013 because he thought there was a right of first refusal for you to care for the children? Isn't that true?
I'm going to object to speculation as to what Michael thought.
Thank you.
If she knows her. Didn't Michael convey to you in a letter on October 15, 2013, that please show me your order where there's a right of first refusal?
I don't recall.
You don't call it. And, in fact, Michael told you 3 days after that email you offered to the court that he's talked to his attorney and you're not entitled to overnights and he's going to get a nanny for his days that you would be able to pick the children up during your custodial periods during the day. in
Objection,
October, correct?
objection, clarification as to what email is she referring to in her question.
October 15, 2013. On or about.
I really don't recall. I would have to see to refresh, because if I remember correctly, no, I need to see that, because I think he said something different.
On August 14, 2013, around noon, Mike wrote you and said, I've decided to use a nanny for the time I'm out of the country, referring to October. Thank you anyway, but dealing with you has become increasingly difficult, and I don't need it. I just need solutions.
What date was that?
That was August 14.
There was a new one that was
I'd
sent.
object to
That
the
was
form
in
of the question.
August.
She's reading evidence that's not admissible in discovery.
I'm asking if she recalls us.
Sustained, rephrase, counsel.
Isn't it true that Mike challenged you and said, no, I don't have to be forced to give you the children when I leave in October? Isn't that true? There were emails discussed with that. You didn't agree on whether you should have the children.
Actually, that's incorrect, no.
Okay.
Because he offered the children back in June of 2013 before custody had changed by email.
Okay, so he offered it in June. Mm-hmm. Then he told you on August 14th, I'm using a nanny.
That was because he was angry because I had not responded to him yet.
And then you told him that same day, 10 minutes later, it's not acceptable to you. Isn't that true that you told him it's not acceptable that you'll leave the children with the nanny instead of me, correct?
I would like to see it so I can actually read it.
It's August 14, 2013 at 12:12.
I have no question.
I
I've
may
seen it.
approach to refresh.
I did.
Okay.
I read it. I do say in
Okay.
here.
All right. She's answered the
I'm not
question.
finished.
She only asked you whether you read it.
Okay.
She didn't ask you
So
what it
you
says.
disagreed with his viewpoint.
I think you're taking that out of context, Ms. Vaccarino.
All right. And then, basically, there was nothing else mentioned about this trip until Michael wrote you on October 15th and told you a long letter explaining to you that you cannot, he cannot agree to allow you time other than that was court ordered, especially because you still had not taken the drug test ordered to be.
I'm going to object as to form of the question. She can't read stuff into the record to get it in when she hasn't produced it in discovery
Sustained.
or put us in notice.
Do you recall Michael warning you that the reasons why he didn't think you should have overnights as of October 15, 2013?
No, I do not.
Do you recall him telling you
Can I ask a question? Are you referencing a letter from yourself?
No.
Okay.
Although you said letters from attorneys come in as hearsay at the last hearing.
I'm just trying to figure it out.
Isn't it true that I'm sorry, it was October 17th, 8:30 in the morning. Michael wrote you and said he consulted with me. Do you recall that day, October 17th?
No, I do not.
You don't?
I recall October 17th, but I don't recall that email from him. I would like to be able to verify that in my own emails.
Okay, he was said, don't you remember Michael reminding you 3 months later you still need to take a drug test per Judge Nathan's order? Do you recall that or no?
No, I don't. I would
Let me
like to.
approach to refresh your honor. I'm only doing this because she doesn't recall.
Yeah, but I mean, to a certain extent, there is a little bit of backdooring of evidence that was never produced during the period required.
She has all these. There's no fair
That's,
surprise.
that's not the point.
The problem is, I've never
It's not
seen this
that.
before.
I
I've got
asked
a-
him yesterday if she's lied about this and to carefully do a Rule 11 investigation. Because they
I'm not-
cherry picked.
If Mr.
You've had a
I'm
month now
allowed
to
to
give me
impeach
these
this
things.
way and
If
refresh.
Mr. Mullins has not seen the letter, it's not going to be shown to the plaintiff.
Your Honor, what's your evidentiary basis for not allowing me to cross-examine her?
The rules.
The rules of evidence.
Oh, thank you, Your Honor. Your Honor, what rule of evidence would not allow me to ask?
16.2 to begin with.
I'm not on discovery. I'm on cross-examination, Your Honor. And
Yeah.
I'm not meaning to be rude,
And
but
anything
my
that
client's
might be
being
used,
handcuffed
why
to
don't
not
you
bring his
reread
case to impeach her.
16.2? 16.2 is very on point. And I am exercising my discretion not to allow this letter to be used.
You're abusing discretion by not allowing me to impeach her
Then
on a
feel
huge
free to
issue.
take me up. I am
Can I take
excluding...
you up on a writ?
No,
so
because
that
we're
before
finishing
you
the trial.
Before
Guess
you
what?
finish this trial and
No,
damage...
I'm going to be ruling today, and then if you want to appeal it, you're certainly free to do so. But I am ruling today,
You still
and there's,
need to
I'm
address
not
child
continuing
support.
this trial to allow you to take up a writ. You can take up the whole shooting match if you want.
Well, Your Honor, if you're saying that I cannot...
Ms. Vaccarino, I've already
proceed-
ruled. Now move on.
So, isn't it true, as of October 15, 2013, you had not drug tested since July 19, 2013?
That is true, but I was unable to.
No.
Just answer the question. It's very simple.
When you're a paralegal, correct? Or you were?
I've done some paralegal
Are
work.
you still doing paralegal work?
No.
Okay. So, were you in court? Did you take any notes on what was required of you as of July 19, 2013?
With every, no, I didn't.
Were you aware that you were ordered to test a week later by July 26th at ATI? Yes or no? Or you forgot that?
I believe you're incorrect on that. I was actually supposed to test by July 19th, and I did not receive the court order, and July 26th was pertaining to the HIPAA release, Ms. Vaccarino, which Mr. Sachs sent to you.
So you think you were supposed to test that very day?
That's what I believe the minutes read.
And you left the court believing you had a test that day, correct?
By the time we left, which was 5
Yes or no?
p.m.
Did you believe you had a test
No,
or not?
actually I didn't, because I never received the referral slip.
So when you realized on July 19th that you didn't receive a referral slip, you called Judge Nathan's chambers or your attorney?
I actually went to ATI and attempted to test.
And did you get a referral slip?
From ATI, they wouldn't give me one.
Did you file anything?
I signed in on their book with them, and they wouldn't give it. Then when the minutes came out on August the 6th, I took the minutes down to them so they could read them, and their exact words to me were they would not allow me to test because it would report as
I'm
a
gonna object to
fail
hearsay, Your Honor.
because of the way the minutes had read.
I'm going to object to strike the hearsay.
Overruled.
Did you bring in any ATI witnesses to bolster your claim of attempting to test?
I didn't know I would need it to, but they did inform Mr. Hoskins
So,
in
in fact-
December of 2014 or 2013 that I had been down there trying to test. That's
Your
why
Honor, I'm
he
gonna
approved
object now
it.
to double
I'm going to
hearsay.
object as to this whole line now as to relevancy. I've allowed it. I've not said anything, but
You're
she
sweeping
didn't
the whole-
prove in 2013 in July at trial that this lady was a drug addict. She didn't prove it at all.
Your Honor-
There's never a finding by a court that she couldn't
Closing
take
argument.
anything. And now, after an hour of this, she has established nothing about whether the lady had a drug problem before, and she's, more importantly, not established that the lady has a drug problem from July 19th to now, which is the relevant evidence you have. How long do we got to sit here and have the two of them, without having the same documents in front of them, talk about whether or not there was an order made or not made, whether she went or didn't make? What's the difference? Even if she missed 5 of them, he got primary physical custody, and we filed a motion to modify because he didn't do his job since then. We didn't in our motion, it doesn't say we're moving to modify because she used to have a drug problem and now she doesn't. Our motion says
That's what
she never had one.
Okay.
Okay, so on July 19th, 2013, you did not have a drug addiction, correct?
No, I was under pain management.
Okay, so why didn't you just testify that day and ask for joint custody? Tell the court. If you were, let me withdraw.
Would you like
Your
me to?
testimony is that you were on a methadone drug and you were taking it as prescribed, correct?
Yes.
And your testimony also is that instead of being tested that day, you stipulated to let Dad have primary custody, correct?
That's incorrect. That was not the stipulation, Ms. Vaccarino.
So you had
And I
a
also
choice.
believe
You
that
could
was
have
for
te-
90 days. I have always thought that was for 90 days, Ms. Vaccarino. You know
In
that.
July of 2013, you knew it wasn't for 90 days because the judge said, I'm not doing 90 days. She
Yeah,
yelled
and
at-
then when the minutes came out, Ms. Vaccarino, they were ambiguous and they looked like they were for 90
You believe
days.
the minutes were ambiguous, correct?
When I look at them, yes.
So now you had a choice to either go forward on July 19 and testify or enter into a 90-day or forever settlement, correct?
Would you like me to explain?
That you had a choice, yes or no?
Would you like me to explain?
I'd like you to
Answer yes or no.
I had it.
Did you have any choice?
Did I have a choice?
To stipulate or go to trial?
To a certain extent,
What was your choice?
to either stipulate or go to trial, but I wasn't prepared for trial.
What did you need?
I had nothing. I wasn't prepared.
You
You
had
had
the
been,
testimony, correct?
well, Ms. Vaccarino, you've been sending all the discovery to Aaron Grigsby before he was withdrawn. As a matter of fact, I don't even
Your Honor,
think
I
there
would
is an
object and move
order.
to strike.
Overruled.
You'd sent everything
So
to
your
him.
choice was to make a stipulation instead of testifying as to custody issues, correct?
I was there with a pro bono attorney.
That's a yes,
I was
sir?
unprepared. It was a mess.
And there were 2 continuances already of trial before July 19, correct?
There was only one continuance at our request. The other
What
one
did you
was by
have
the
to hide
judge.
on July 19th?
I had nothing to hide.
So why
That's why
didn't you just go forward and testify about your allegations of domestic violence? Why didn't you do that? Why didn't you want just to have your sides told like today? Tell the court.
I had been told by Mr. Sachs at that point that we couldn't bring up the domestic allegations because of your overturn with the DFS.
Oh, okay. So why didn't you just go forward and testify to other matters? For instance,
I'm going to
Dave-
object as to relevancy, as to why she did or not do something on July 19th that
The reason
resulted
why
in...
you're-
We are going past July
For the record,
19th.
he's saying that
We
we
are
never
going-
alleged she was a drug addict.
We are
They
going-
No, no, I said you didn't prove it.
We didn't have to prove it. She stipulated.
You could have, right? You're asking her to prove something that she could have done, and I'm asking you, why didn't you prove she was a drug addict on July 19th?
I had all the exhibits ready to go on July 19th.
Oh.
Then you should have proved it.
I am sustaining the objection. Move on. If you want to ask her anything subsequent to July 19th, feel free to do so. But
Your Honor, you can't get to substantial change if you don't know the history. That's my concern of why I asked you to allow
Sure I
me.
can. I'm actually making assumptions. I'm predicating my assumptions on what you're asking me to believe were the facts on July 19th, with all due respect to Mr. Mullins. Now, if I'm going to go, you either have 2 choices. You either concede you never proved that there was a drug addiction problem, and therefore, on that basis, there's no change of circumstance, or you ask me to find, for the sake of change of circumstances, that it was effectively a finding of drug use. Pick one.
I'm asking her which one it was.
Yeah, but
I can't-
I'm the one that's ruling. You don't ask her to rule. And as far as I'm concerned, we're done with July 19th. Move forward in time.
So, you did not file a motion to change custody prior to July 2014, correct?
Correct.
And in fact, you wrote Michael, there's emails attached to your motion filed July 2014, wherein you told him, let's go to mediation and make a fresh start like the judge said. You remember writing him that?
Can I review those to make sure you're accurately dictating them?
Absolutely.
What exhibit are you looking at?
I'm going to try and find it. I'm assuming it's going to be my motion to change custody is the one
Is it in
she's
there?
discussing. It should be in here, right?
It's not in there.
It's not in there. Okay.
Her motion isn't in there now.
She'll show it to you if she wants you to see it. Found it. Can I show it to her?
Is it filed July? Yes, yes. Thank you very much.
And that was for the mediation that Judge Pomerantz ordered us to attend. And I was trying to be optimistic and positive.
So you told Fresh Start meeting, and the judge also said that both of you couldn't look backwards, that what problems you had both happened, she wanted you to look forward from March forward, correct?
Correct.
Okay, but your motion that you filed doesn't do that. You waited till July, and then you complained about stuff that happened back in October of 2013, correct?
I was never allowed the opportunity to bring those items up because you never filed in your opposition, Ms. Vaccarino, to my
Okay.
set-aside,
So
which
you-
Nathan said I could bring them
Instead
up.
of, you marched to the school on October 17th, 2013. 6 hours after Michael wrote you and said, I don't agree with you, you cannot have the children when I'm in Spain starting on the 26th, didn't you?
I do not remember the email from him. I was actually called by the school to come pick up the children because they were sick, because he had sent Dylan to school with a fever and ibuprofen, which I had emailed him about.
You emailed Michael and said, I'm picking up the children on your custodial day that day on October 17th?
The school
Yes or
called
no?
me. The school called me.
After the school called you, you failed to, allegedly called you, you failed to
I-
contact Michael until after you picked up the children.
I don't think so. I think I actually had let him know.
Okay, you're not sure.
I can't recollect on that because there were so many emails going back and forth between he and I.
It's October 15th at 2:34 a.m. 2:24 a.m. is what she said. 2:24 a.m.
The 15th?
You wrote Michael on October 17th at 2:24 before school even let out, or just after school let out. What time?
I'm going to object to the form of the question.
Actually, that's
Wait.
I'll
Overall,
withdraw the question. Isn't it true that you went to school on Michael's custodial day, Thursday, October 17th, and picked up the children before school ended, all of them?
I have an email that I sent
Yes
to
or no?
Michael at
She didn't
2:01.
ask you that.
Yes, I did.
Okay. You did not write Michael first to say, I'm picking up one child because he's sick. You didn't do that, correct? Correct or incorrect?
I'm looking at an email right here that
What
says
one?
I did.
Oh, okay.
October 17th at 2:01 p.m., where I said, how long has Dylan been sick? Has he seen a doctor? Have you been watching him to make sure no fever? Or did you just send him to school because you don't want to call me so I can take him to the doctor and make sure he is okay? He has asthma, and every time you do this, you risk our child's safety. Remember when he got pneumonia, and again, you said he wasn't sick? And this was Michael's response. Dylan is fine. Get that court
I'm going to
visit
object,
together.
Your Honor. I didn't ask her to read the entire thing. I asked her if she picked up. Did you ever in your letters, I'm going to ask to move to strike her testimony that was not responsive.
overruled.
Of course. Did you...
I'm going to object to that comment.
Sustained.
Did you ever tell him, I'm picking up all three of our children today before school ends? Yes or no?
It's a possibility. I would have to go back and see.
And in
It's,
fact, you didn't tell him until right after school ended, when you picked them up early at 2:24, that you're taking custody back.
I did do that, yes.
You didn't tell him I'm caring for them while they're sick and bringing them to the doctor, correct?
Just answered you and said, yes, I did say that to him. Because
And
I
you
had
gave him
believed the
a
90-day
you gave him-
stipulation had ended, Ms.
You
Vaccarino.
gave him a laundry, no, you didn't say 90 days. You gave him a
I had actually sent him 2 emails that day.
You gave him a laundry list of reasons of why you needed to have custody of the children, correct?
One of them was being that Daniel had autism
Yeah.
and was not in therapy.
Okay. You didn't have him in therapy in 2013, though.
Actually, I believe Daniel was. He was getting therapy at Linda Gibbons more aggressively. They have a certified autistic program, so yeah. And Michael also withheld the insurance cards from me and didn't give them to me in January of
I'm gonna move to strike,
2013.
Your Honor.
You opened the door, counsel.
No, she's non-responding and adding stuff, and you're letting her go on. You know what?
I want to admonish her in front of everybody. Listen, you got a lot
You
to
know,
say.
Okay, I guess I'm
stop
sustaining your objection. I'm striking.
That's
Mr.
fine. Start
Mullins,
again.
please admonish your
But
client.
let me just make sure we're clear here. You have a lot to say, and I'm going to go through this with you. This lawyer, a really good lawyer, has a right to ask you the questions she wants to ask. The fact that you have more to say doesn't mean you get to say it. And this judge has been patient.
Yes, she has, and thank you.
I know how hard it is, and she does as well. Go ahead, Patricia, I'm sorry.
Isn't it true that in the afternoon of October 17th, you provided at least 10 reasons why you believed you needed to have sole custody of the children as of October 17th?
That was
2000.
in that email only. There was
Is it yes
another
or no?
one.
That's a yes then. You did do that.
Yes.
You didn't say it's a 90-day reversion. You gave 10 reasons.
There's a second email, Miss Vaccarino. You're not being...
You had 2 reasons.
Do you have...
Thank you.
My main reason was the 90-day stipulation, and then the other reason was because of all the stuff that
You
had been
didn't
going
file a
on.
motion first. You just self-helped and picked up the children as you desired.
There
Correct?
wasn't an order in
You
place.
just said the order was ambiguous.
There
Didn't
was a
you?
minute order, but
Okay.
it had never had a notice of entry.
That it was ambiguous, but you took it
It
upon
was
yourself.
ambiguous, and it looked
I'm
like
going to
the
object to
90
this.
days.
She was the trial lawyer and had from July 19th
Your Honor, I'm going
to
object
prepare
the
the
objection.
trial order, and it's not even November yet. And that's because she didn't do her job, and she's grilling her about the meaning of the order.
Objection, Your Honor.
Overruled. Cross-examination.
You picked the boys up because Mike told you that morning that you would not have a right of first refusal 10 days later.
No, I
correct?
did not.
Okay, I have nothing further.
Amy, did Judge Giuliani ever make a finding, or did Judge Nathan ever make a finding, that you had a drug problem?
No.
At any time, to your knowledge, has Ms. Vaccarino's office ever done a custodian of records deposition to any of your medical providers?
No, they have not.
At any time, did they produce a request for production of documents that asked you to produce your medical records?
Not that I have seen.
At any time, did they take your deposition?
No.
At any time, did they notice any doctor's deposition?
No.
At any time, did Ms. Vaccarino get any ruling from a judge that you were a danger to your children at all?
No.
At the time that you went into the July 19th hearing, was it your understanding the two of you had an agreement regarding custody?
Yes.
Okay. Did you have your custody taken away that day as a result of your agreement?
Yes.
Your agreement?
No, it was their agreement,
Then
actually.
you stipulated in front of the judge to the custody arrangement. Did you specifically tell the court that you were not stipulating that it was in the best interest of your children, but that you were stipulating because you can't prove your case?
Leading nature.
I'll
Redirecting her.
rephrase it. What, do you
Telling
remember
her
what you told the judge?
I do.
What did you say?
I told her that I was making the decision to agree to the stipulation because I was not prepared, but it had nothing to do with the best interest of the children.
All right. Now, in October 2013, 90 days after this trial, a bunch of emails and stuff went back and forth.
Yes.
To your knowledge, did Michael communicate to you prior to his departure for Europe that he did not want you to be the person watching your children while he was in Europe?
No.
Even when you sent him the email we admitted into evidence at the last hearing regarding the Brussels thing,
Correct.
did he state in that response email, I don't want you to have the kids for this extra week while I'm staying in Europe. I think you're a danger.
No.
What is the one thing you've been accused of in this entire case since 2012 or earlier?
That I was a drug addict and that I was a danger to my children.
And Judge Giuliani heard all those allegations.
Yes, she did.
And did she hear other allegations you were making against Michael?
Yes, she did.
And the temporary order that was in place before Judge Nathan on July 19th
Objection,
had what
Mike
visitation
Monagle.
schedule?
Objection. You said you don't want to hear before July 19th.
I'm just getting a little leeway based upon what she said.
You know what?
Didn't make findings.
Can we move on?
Sure,
The temporary.
absolutely. email come in that we talked about?
It's number 21.
Let's suffice it to say the court is aware of the record in this case.
That's fine. Amy, let's just talk about after July 19th. The first pain medication you ever got was what?
After July 19th was a prescription for hydrocodone.
Okay, and you
Oh,
were on
actually,
that.
let me correct that. The doctor had written me a script for oxycodone, or not oxycodone, but Percocet. It's in my prescription report.
Where's her prescription?
And I actually went in 2 weeks later. It was during some of the dental work, and I didn't want to take Percocet, so I'd asked them to write me a script for hydrocodone.
All right. Did we produce in discovery to Ms. Vaccarino your entire prescription report?
Yes, we did.
Where did you get that prescription report?
From the pharmacy board.
Okay. The pharmacy board.
Yes.
Where have you been a resident?
State of Nevada, Las Vegas.
Have you ever gotten a script in another state?
No.
Okay. So to your knowledge, does the discovery documents we produced to Ms. Vaccarino that has all of your drug prescriptions in it, does it have, is that a complete report of every drug you've ever taken?
Yes, it is.
And approximately when do you think we provided that to Ms. Vaccarino?
I'm going to say, I think it was either October or November of 2014 through
And
discovery.
do you remember any correspondence from Ms. Vaccarino asking for any additional drug or prescription information for you?
No.
Do you believe, and as you testified in your first proceeding, that you've ever abused a prescription narcotic?
No.
Did you ever go to two doctors at the same time to get the same medication?
No.
Is the drug that you've been taking since January 2014, what did you call it?
It's Tramadol, or the brand name for it is Ultram. It's a non-narcotic.
Okay. Have you been, other than the pain, pulling the teeth issue in November?
It was in December.
December?
And then the baby.
Right. Now, at the time of the December 17th hearing in front of Judge Nathan, when you were making that was the day for the hearing your motion is set aside.
Correct.
Did stuff come up in that hearing that the judge was telling you you'll be able to brief later
Yes.
after she prepares her opposition?
Yes.
Honor,
Did the judge order her to prepare her opposition?
May I object
She did.
without them screaming over me? I have to object to the continuing leading nature. Almost his whole case, I've watched the video and I ordered the transcript, has been on leading questions.
Sustained, counsel, rephrase.
Did she follow the judge's order?
No.
And even at the time that the child support ultimately got ordered, had you ever received by that date an opposition to the set-aside motions?
No.
Now, by this time, December 17th, you had not seen your children for approximately how long?
I think it was 44 days.
Now, at the last hearing, there was a discussion based on her cross-examination about whether the Brussels notice
Yes.
was, did you go back to your email chain or text message chain or whatever you were doing?
I went into my email inbox, yes.
Listen to the question. Did you go back and look at it to see whether that was an authentic or appeared to be an authentic email response from Michael saying that he's in Brussels, he's not coming back yet?
Yes.
Did you receive any motion from October 17th, when they allege you took the children from him, through November 5th, when the children were returned to him when he got back from Europe? Any motion by Ms. Vaccarino or anyone else on Michael's behalf that suggested that you violated the court order by withholding the children?
No.
And in fact, she could have made that argument on December 17th.
Your Honor, I'm going to
after
object to speculation. I'm not on trial. It's irrelevant what I did.
No, and I think the evidence can speak for itself, so it's sustained.
What are you trying to get in now? Has there, she didn't ask you.
Why didn't she file?
To your knowledge, has Ms. Vaccarino and Michael's only allegation against you that you are an unfit parent been revolving one issue? Has there been, to your knowledge, any allegation other than drugs as the reason why they claimed you were unfit?
No, that was
Has there
it.
been any other reason why, to your knowledge, that they've alleged in any way that you should not have your children when he doesn't have them?
No,
In other words, they haven't said that you've abused them?
no.
They haven't said that you don't give them adequate...
Objection, Your Honor, leading.
It is leading.
Have they
And
ever...
it's conclusory. You really don't need to emphasize the point. I get it.
Did Michael take the children to Utah without permission?
I'm going to object, Your Honor. This goes outside of the scope of my cross-examination.
Oh, that's fine. What else are you trying to get in?
So I know you wanted to get into autism in school,
I'm going to do that with Michael.
and then that's all school stuff.
You were trying to explain at some point, and you were not allowed to explain the Judge Giuliani medical reports, what she was asking from you.
Yes,
Did you, to your knowledge, produce the letters that the judge wanted?
yes, I did.
And that was 2 years ago.
Yes, it was.
And throughout this case, since your motion's been filed, has Ms. Vaccarino challenged us in any pleading or discovery request to clarify that issue or to say that those 2 letters were not acceptable anymore?
No, she has.
Did you ever get notice from them that those 2 letters were objectionable in any way?
No, I did not.
Did we ever receive in discovery in this matter any contrary evidence that would suggest that those 2 letters are not authentic or that they were not, shouldn't be relied upon in any way?
No, we have not.
Did you provide the HIPAA releases on several occasions to Ms. Vaccarino?
Yes, I did.
And did you learn that she didn't use them?
Objection, Your Honor. Foundation. And because this 3 times we've gone around this bush, 4 times with Judge Giuliani.
I'm going to withdraw it. I'm going to withdraw it.
Good.
In fact, I'm going to, I think the judge got the point. I'm going to pass the witness.
A few questions. You've received a copy of Michael's passport verifying the dates he was out of the country in October of 2013, correct?
No, I did not.
You didn't?
No.
Okay. Your claim is that he was gone for 10 days and he was in Spain and then Brussels, correct?
I'm only going off what his email said.
Where is the electronic device where that Brussels email was pulled off of?
Right here.
Okay. And we provided the passport evidence yesterday to show you that he was only gone from the 26th and he came back on the 30th.
I was not received any of that. I'm sorry.
And in fact, on October 31st, 30th, when Michael came back into town, he brought the police to your house to attempt a civil pickup of the children. Do you
No,
remember that?
I do not remember
You don't
that.
remember that because you testified on December 22nd that he was gone for 10 days.
That was based on his own emails.
But now you recall the police did come to your house.
I never said that. I said, no, I don't recall
The
that.
police came to your house on October 30th, correct?
I do not recall that.
You recall them ever coming to your house to get the children back to Michael?
That was in the very beginning. I think it was October 19th, I believe, is when it was.
It was before he left for
It was before he left,
Spain,
yes.
And then twice, and then after he came back, he tried again with
Well,
the police.
incorrect. He actually did a welfare check, too, in there.
Okay. And you didn't turn over the children back to school until November 5th, correct?
That was after I received the written order in the mail, Miss Vaccarino.
They missed, your children, between October 17th and November 5th, missed 9 days of school on your watch, correct?
Actually,
I'm going to object as it goes well beyond my direct.
He talked about this on the...
And,
Really?
yeah, what's good for the goose is good for the gander. You objected when he went
He'll
beyond.
testify to that, that's fine, you're right.
That's fine.
And the school records show that, too.
Any other questions?
Yes. Tell the court, you said there's some order that ordered us to file something on December 13th. There is no such court order entered ordering Michael to file anything after December 17th, 2013.
you were
Correct?
supposed to prepare it, Miss Vaccarino.
Is there any order? I move to strike, Your Honor.
Overruled.
Is there any order on file?
You never prepared it,
Why
no.
didn't you prepare it if you were so sure I was ordered to file something?
Because it would have been a fugitive
Objection,
document.
Your Honor. He's answering.
I could have answered that.
You know, I'm going to overrule the objection, but I don't know that it assists the court in any event, this area of inquiry.
Well, you're saying...
It's not assisting the court.
Well, she's saying that on her redirect that there were 44 days.
Please remember that all my decisions that I make in any custody case are always child-centered. So for the parties to be slamming each other
Well,
on
missing
a
school
bunch
is
of
important.
points. Go ahead, finish your examination, and let's
Isn't
move
it
on.
true that right after you swiped the kids from school on
This is
October
first, that's one.
17th, that you filed a motion to recuse Judge Nathan off the case? Yes or no?
I filed that on October 22nd, yes.
And during that period, you bragged to Michael that Judge Nathan can't touch this case, so you can't do anything, you need a pickup order. In letters, you bragged to him saying that.
I don't believe I said that exactly. I would have to see him to recollect,
Okay.
but if,
So you might have said something like that between October 22nd and November 4th, correct?
some of that stuff that was going on between he and I
Okay, yes
after,
or no? You might have said that.
it's a possibility, yes.
So, you basically told him, I have the children now, and you can't get a civil
I'm going to
case.
object, goes beyond direct.
No,
Sustained.
Your Honor, they were talking about this period.
It goes beyond the redirect.
Okay, you said you lost the kids for 44 days between November 5th and December 17th.
Beyond
44,
redirect.
There was a 44.
Beyond redirect.
No, it's not. That's exactly what she said on redirect. It was 44 days I didn't get to see my children, and I'm trying to explain why.
Well, then have your client explain why.
Your Honor, why can't I ask her? She filed a bias
You can ask her
motion.
and she's answered, and I'm not
Isn't
sure.
it true that you filed a bias motion, and Judge Togliatti took it under advisement and didn't even hear it and rule a decision until December 11th?
They don't hear.
Yes or no?
I would like to explain.
Is it true that Judge Togliatti ruled on December 11th on your bias motion filed October 22nd? Yes or no?
It's true, she ruled
I
on
have nothing
December
further, Your
11th.
Honor.
Okay. Thank you, ma'am. You're excused.
My next witness is Michael.
What do I put up?
It's Exhibit A.
This is the below this together.
He has pictures of his children he wants to bring up there, Your Honors, and
No.
he can't. Okay, she doesn't even want you having the children. It's a sensory perception thing, but that's fine.
No, he can't
He's-
bring anything up unless Mr. Mullins is
Okay.
agreeing.
That's fine. These are his interrogatories, and that he needs to refresh his recollection, but we don't.
We will wait till Mr. Mullins finishes his
Thank you,
examination.
Your Honor.
You do solemnly swear the testimony you're about to give
First
is
book.
The autism
the whole
referred to
truth and
in
nothing but the
3,
truth, so help you God.
9,
Thank you, please be
and then the
seated.
second through 10.
Mr. Dziedzic, where do you live?
7319 Plantanis Road, Las Vegas, Nevada, 89113.
Has there been a time since this case was filed where you actually moved to Utah?
No.
Could you please turn to Exhibit...
Am I to use this? Is that
You
what this
would
is here?
use those,
They're both,
yes. Would you please turn, do you remember referring the court to a July 1st, 2014 email that you had written to Amy explaining the position that you didn't move to Utah? Do you remember making that argument?
Can you say that again?
Do you remember the
please?
motion filed by Amy? And it accused you of relocating with the kids without court permission?
Wasn't that in August?
I didn't, it doesn't matter.
Okay.
Do you remember your response to that motion?
My email response to her?
No,
after she
your
did it?
general response to that motion. You remember?
I think you're being vague. I don't know specifically what you're talking about.
Okay. Do you know if you and your lawyer filed a written response to the motion that Amy wrote saying that you had wrongfully removed the children?
I can't recall. I'm sorry.
All right.
I would assume my lawyer would respond to it, but I'm only saying that out of assumption.
Okay. Following that train of thought, do you know why your lawyer didn't file a response, or you didn't file a response to Amy's motion to
Yes,
set
I do.
aside? That
I
was
do.
filed on November 5th?
Because we were admonished by the judge to fix our problems between us and even sent to mediation.
And, okay. And was there an attempt to fix the problems between you?
Yes.
Not the July 1st email. Please turn to Exhibit 58, please. It's in the second exhibit book, second white one.
This one?
Is this the we just got today?
Yes.
Okay, Your Honor, we got exhibits, just for the record, 58 to 74. We just got them this morning. We will object, just like you said to me. I mean, our
All
answer-
produced in discovery.
I can't finish. It doesn't matter. Trial exhibits are supposed to be provided so we can make an objection and review them. It's the same kind of ambush. Our records were provided back when, and we did in our interrogatory response say, you have all the emails, just have, everything's fair game. So we're going to object.
I'm going to sustain your objection with the proviso that on a very limited basis, you can use it to refresh recollection.
Can I be heard on it first? Everything that I've objected to for her has been because she didn't produce it in discovery. Our discovery, Your Honor, was this long, this big.
I did have an order.
Wait a minute. Prior to trial, I reduced it to this, not knowing, all right, that they're going to be objecting to stuff like the Brussels email. So I have to have a way to go back and get evidence. So, for instance, a July 1st email that was produced and attached to his motion, I produced it in discovery. What objection would there be? There's no rule that says that during the trial that I can't go back and grab additional evidence out of discovery to use to cross-examine.
Actually, I do have a rule on that. When I set an evidentiary hearing, I say the parties are to exchange their list of witnesses and any exhibits they intend to introduce, and that they will, if anything that's produced late, will not be permitted to be presented absent compelling cause. So please provide me with compelling cause
I want to make sure.
why you can't go beyond refreshing his recollection.
I want to tell you that if that's the rule you would like in this courtroom, then every single time I have a trial in front of you,
Objection, Your
there's going to be
Honor.
5 books this
Objection.
big, because how do I know that documents that I think are going to be resolved?
Counsel, I'm not going to tell you how to try your case, but I do think it is appropriate on both sides that there be a minimal amount of ambush.
There's no
And
ambush.
This exhibit has existed. You could have produced it to Ms. Vaccarino's office
I did.
quite some time ago, because what that tells Ms. Vaccarino is that, in fact, you intend to use it, and then she has the ability
This is on
to
your
evaluate
response
it.
to my motion.
Your Honor, these are documents that they produced in their response to the motions that I reproduced in discovery and date stamped.
I
It's
just
number
got-
33 of the documents that I gave them. I'm not going back and ambushing and giving them a
Counsel,
document. I'm not doing
Please
that.
dial it down. And I will tell you right now, I make that point because both parties have to prepare for trial. I don't think I'm remotely unique in this view.
I'm
And
just-
if a party comes up with a document that could have been produced
It was produced.
as ordered, because it's something that indicates you're going to use it, then absent compelling cause, if it's not produced on that deadline, then it doesn't come in.
It was for all the documents I'm saying are
Produced as this is a copy of a document I may be using at the time of trial.
All right,
That's
so-
a different thing than producing it in discovery.
All right, in addition to that, there's going to be exhibits here that say that since we were last in court, their child has been suspended from
Objection,
school
Your Honor. Objection.
because of the autism problem. Do I get to introduce those?
Oh, you can sure cross-examine, you can sure examine him on it.
He didn't examine her.
You can examine it, but
Absolutely.
as far as producing documents, no. I'm going to put you to the same standard that I put Ms.
Your Honor,
Vaccarino.
there's no evidentiary basis for that standard. You can do whatever you'd like, and I'm going to shut up after this. The rules say if you produce documents during discovery, you may use them at trial. There's a local rule in your order that says you got to produce exhibits before the trial. That doesn't mean you can't go back to your discovery and produce additional exhibits.
Well,
I mean,
I think that we disagree on the interpretation of the rule, counsel.
All right, that's fine. It's
I
fair
didn't
enough.
get an opportunity to object.
You don't even need to, because I've already ruled in your favor.
I passed the witness.
You're done.
I'm done. I'll cross-examine him when you're done.
I have no questions.
We're done.
On cross-examination, I have no questions on him. I may call him in my case and
That's fine. I'll cross-examine him if you call him.
Oh, then whatever way you want to
That's fine.
prove your case. You have to
All right,
prove
have
it's
you
substantial.
rested?
I've rested.
Rested? You're not calling one?
Well, actually, I called Jen. What's her last name?
Becker.
Jen Becker.
I don't believe she's in the courthouse today.
She was under subpoena.
And you didn't issue a check to her.
That's fine.
And witness fee. So
You
she's
think
not
she's
here.
outside then, counsel?
No, I don't think she will be, but I'd like you to yell her name.
Jen?
She's not
Jen
here.
Becker.
If he wanted her to come again, he should have notified her. And he did not provide a witness fee or a mileage fee, which I know, right? He's Can't complain on that.
No, ma'am.
She's not here. And if she didn't get the witness fee, unfortunately, I can't sanction her the $100.
I'm not trying to sanction her. I'm just trying to make sure his girlfriend was under subpoena. She didn't come. That's good enough.
She
for me.
was here all day last time, Your Honor, ready to be called.
Screaming.
Yeah, screaming in the hall and listening to the
Objection,
hearing.
Your Honor, to move to strike testimony of the plaintiff's counsel.
I
Or if I
rest.
may move to strike.
I rest.
Okay, then,
Dr. Reno, call your first
at this
witness.
time, you said I would be allowed to make an opening argument before my case in chief, because the start of court last time you
As long
were.
as it doesn't contain any argument.
Okay, Your Honor. Okay, put the facts.
And you have 5 minutes.
Thank you for the court's indulgence.
Please pay attention to the clock.
Okay, thanks. Your Honor, this is what the true facts should show. And before just listening to Amy's testimony, you're going to find, now that they've just rested, substantial evidence in the record will not be found to show that there is a substantial change in either of these parents' lives that has materially affected any of the children. In fact, what you're going to see is during the year when Mom had no overnights, during all of the 2013-2014 school year, except when she stole the children,
That's argumentative, counsel.
except when she took the children from school without, in violation of court order.
Your Honor, she's allowed an opening statement to tell you what she's going to present, and that's it.
What it's going to show is when she took the children, that the children were performing better than they had the 2 years prior in school. That's what the school records of the testimony will show. There was also some issues as to a perspective on Daniel's needs and with his Asperger's, and you will hear the testimony of Michael, which is different, and will show that even when Mom has referred him to websites and he implements those plans, his ideas are more in line with the websites she's sending him to. In fact, what you're going to see is when she left the children out of school for 9 days in October of 2013, it was during 14 of Michael's custodial days that month, during October of 2013. And then in March of 2014, she took another 14 days of unauthorized custodial days, and you sanctioned her for that one when we came to court in March. You were very upset that she deferred back to the old custodial order, and that sanction of attorney's fees
I'm going to
still
object
has
to,
yet to be
again,
paid.
argumentative.
It's what's he's going to testify to.
No, you're telling the judge what happened at previous hearings.
That's part of the facts of the case.
Move on, Ms.
Thank you, Your
Vaccarino,
Honor.
because now you have 3 minutes.
Thank you, Your Honor. Yeah. So what you're going to see is Mom has come up with a bunch of reasons why she was allowed to steal custody of the children.
Objection, argument.
You're going to see that Mom has not shown this court that
Objection, argument.
The evidence will show that Mom...
Evidence will show as an objection. That's
Mr. Mullins, you know what? She now has 4 minutes to argue, or to give me a preview of the evidence. That's what happens when you start objecting in the middle of an opening statement. I'm pretty good at catching what is argument and what is preview of the evidence. Allow me to do so. Okay, you got 4 minutes.
The offers of proof, Your Honor, will show that Dad is very much on board with the IEP and the Asperger's, and this boy is blessed, and he's not considered special needs, and he's meeting and following the advice of the professionals at school, and that the evidence will also show that Dad has a clear, huge concern with the plaintiff's lack of sincerity about Daniel's treatment due to past history and what happened, and that these issues didn't come up until most recently, pending her motion to change custody. The evidence will show you that while Mom has claimed she lost 14 days of time during the period when she filed a motion for bias and said nobody can sign a pickup order and laughed in Michael's face, the evidence will show that Mike's lost, in fact, 29 days of lawful custodial time since July 19, 2013. So if you're going to find a willful or substantial interference of custodial time to change custody, you'd have to find that Mom doubles the count for a willful deprival of visitation. What's also on today, Your Honor, is whether or not you're going to issue an order to show cause on Michael's repeated motion. In October, he filed again for child support and child support enforcement. What boggles the mind is that if you count in that she still owes August, September, and October, and you see the schedules, she's $14,000 in
Objection,
arrears.
argumentative.
No, it's facts. He will produce. You're on today to hear the issue of arrearages, finally, and to reduce it to judgment. And what's public policy, is what's right is that mom step up to the plate. You're going to find that she can't serve the children's best interest if she hasn't shown she can even pay her child support pending this case. So what you're going to find through the evidence and the facts is that they have a different way of operating, but the only time that Mike ever, upon calling the police, upon calling his attorney, was when the case was in orbit due to mom's filings of a peremptory challenge, and Judge Tagliotti's unfortunate, she took it under advisement, it was supposed to be heard in November, and at that point, we were free to file something. Michael was free to file something to get the children back. December 11th has already been a statement of fact and record that's stipulated that that's the day that Judge Tagliotti made her decision, and that was 4 judicial days away from Judge Nathan's hearing. You'll hear in the record that Dad didn't file anything after December 17th because it was settled. They were told to go home and follow the order, and they did. They did fine until Mom once again.
Objection, argument, Your Honor. Now she's telling you what was said at the court hearing.
I'm telling you that what
He wasn't even at the court hearing. She didn't prepare an order for the court hearing. She didn't file an opposition to the court hearing. Her evidence to this
You've got
witness.
another 2 minutes, Ms. Vaccarino. See, we're just going, I hope you guys don't plan on having lunch, and I apologize to my staff that I plan to finish before we have lunch. And that's my apology. And frankly, counsel, that's an apology that should come from both of you to my staff. Move on, finish your opening statement.
I would respectfully request that you allow your staff to take an hour for lunch, and that we will, if he's done with his case in chief, Your Honor, we will finish. And I don't think that's fair to anyone, especially, people that have to question and answer questions on an empty stomach. So, the court will show that every time this case, you've called it your own words, Your Honor, and my client, this rings in his mind, and he'll testify about it. This case is off the rails. It came back off the rails according to my client's belief when she then went in and legally manipulated and set the decree aside and then again played procedural games. What happened was this case started to get back on the roads, and we've read transcripts. My client will testify that he wanted to do what you thought was best and try and move forward. And my client will also testify that the worst thing for an Asperger's child or a child with high functioning autism is to have him caught up in this battle. And that you'll see that the disciplinary problems with his child coincided the week before this case is coming back on. Because these kids are like sponges, and they're affected, and that's what's affecting these children, not Mike's care of the children. That's what we present as we prepared to show you through the evidence today, Your Honor.
Let's go ahead and swear in the defendant. Oh, he's already been sworn in. Take that back. Ask your first question.
Thank you, Your Honor. Please tell the court if you made any allegations that Amy was on anything else but pain medication prior to July 19, 2013.
No, I did not.
And, in fact...
I'm sorry, pain medication and soma, so I guess that's muscle relaxers, so I...
Okay. Did Amy ever tell you, because you were still married to her in 2012, correct?
I was married for her for a month, 32 days in 2012.
Did she share with you during that period that she was taking Adderall?
No.
No. Okay. So, tell the court, what, in your opinion, were there any problems with you and Amy in August and September of 2013 after the agreement was reached in court? Let me be more
I don't know what
specific.
mean
I mean
by
problems
problems.
like, did she ever argue that you weren't giving her visitation as ordered?
No.
Did she ever write you and say, I'm confused about this schedule because the minutes are ambiguous? Yes or no?
No.
Didn't you write her more than once?
Don't you want him to answer the question before you ask?
I did say no. I'm sorry, I said no. Excuse me. That was a no.
And did you understand the order of what days Amy was to receive by stipulation entered on July 19, 2013?
100%.
Can you recite it for the court today?
No.
But you
It's been so many judge
Okay.
decisions ago, I'm sorry, I would need to be refreshed.
And did you ever stop?
I'm sorry, it was no overnights, though. I do remember that
Okay.
specifically.
And so, did she get every weekend?
No, I think I do remember what it was. I believe it was Saturdays and Sundays every other week from 9 a.m. till 8 o'clock p.m.
Do you recall in court when
Saturday and then Sunday.
we asked Amy if she wanted to, while we were making the agreement, do you recall asking if she wanted to gradually do one overnight in between in July? Yes?
She refused.
Okay. And in fact,
Is this during settlement discussions, or is
no,
this
in the record on court, because it's already transcribed. And isn't it true that you understood for the first time that day that there was a new drug regimen in place for Amy, the plaintiff?
We were blindsided by it. So,
Who was
yes.
blindsided?
Myself, I was blindsided because when we went out there and she admitted right away she had a methadone problem, and she wanted me to take the kids while she got help. That was her exact words, and she even said it in court as well. I need to
Objection,
let
the
myself
record
heal.
doesn't say that. This is,
and
It's his,
stricken?
it's his recollection, Your Honor.
No, it's stricken. I mean, you're
Why is it
talking
stricken?
about settlement discussions that should never, ever, ever come into evidence. I'm
In court,
striking
isn't it true that when we've had it transcribed, that after canvassed by the court about that this is an order that you're agreeing to, Amy said that she felt that she had no choice because she was unprepared for trial? Yes?
Oh,
Did she say that the words absolutely fine when the judge asked her if she accepted the stipulation in the record?
she said 100. Yes.
And between, okay, there came a time in August of 2013 when Amy alleges that you offered her a right of first refusal for when you were going to go to Spain in October. Do you recall that?
In an email, yes.
Okay. So tell the court your chronological recollection of the sequence of events. And she's even mentioned the first recollection of this was in June before trial. So tell the court starting in June, when did you find out about your trip?
I found about it at the end of our fiscal year at my job, which is in June.
So June of 2013?
Correct.
And what did you do prior to even knowing about the methadone, you found this out? What did you do immediately
set up-
upon receiving that?
I set up so that she could take the kids for those 3 nights.
Do you think that that's a good co-parenting decision? Yes or no? You have to speak up.
100%, yes.
And would you want Amy to offer you the same if she was out of town for 5 days?
Yes.
Okay. So then continuing in August, there's an email that's been admitted that seems to indicate that you thought you still should offer the right of first refusal, correct?
I was under the understanding that I had to offer her first right of refusal, yes.
Did you talk with your attorney or check the minute order carefully before writing Amy and reiterating that your days of your Spain trip?
No, I did not.
Okay. What happened after you double-checked and spoke to your attorney in August 2013?
I was made aware that I do not have to do first right of refusal. I immediately contacted her with different plans, saying that I have a nanny that is going to come into the house and take the kids for the time.
Did you tell her she couldn't have any of her visitation during that 5-day period?
That wasn't even mentioned. That
Okay.
I didn't even
And
come up.
did you ever mention to Amy anything about the outstanding drug test that was ordered on July 19th? Ever? Did you ever mention anything to Amy that she needed to take her test that was ordered in an email?
Yes, I did. In a subsequent email, or maybe even that email, I need to be refreshed. But I asked her to do what the court requires of her.
Now,
In an email.
Okay.
In an email, I said that.
Can you tell the court, how carefully have you gone through and scanned and scoured the email records between you and the plaintiff since December 22nd?
I've gone through certain portions, but there's so much I haven't been able to get through it all.
Isn't it true that you were concerned? There was certain testimony came from the plaintiff that where she says you sent her an email that you went to Brussels, and you recall that?
No.
Do you recall her testifying about it?
Yes.
Do you recall me saying that we're concerned with the authenticity of that email?
We objected on that email.
And have you looked through all your email
Number 58.
records from the date of that, when you were allegedly in Spain, Did you review your email records, and did you find that Brussels email?
I did review my records. I did not find it.
Okay. And in fact, she's stating that you told her that you would be in Spain and Brussels for 10 days. Do you recall that testimony?
Oh.
That you recall Amy testifying that she believed you told her you would be in Spain and Brussels for at least 10 days.
I'm going to object. It mischaracterizes her testimony. She found out, her testimony was that she found out about him extending the visit when she wrote him on October 30th, which was the 5th day. At that point, she claims that she was informed. Her testimony is not consistent with that.
So on October 30th, she says that she informs, that she thinks you informed her you're going to Brussels. Yes?
I did.
Okay.
Oh,
Now, you returned to the States on October 30th, did you not?
I did.
Okay. So it's your word against Amy's of where you were on October 30th?
Apparently so, yes.
Did I ask you to look at any objective evidence to show the court that your itinerary of when you were gone is accurate?
Yes.
What do you have to explain to the court that you looked at to verify your dates and how you acted in good faith?
I have two different ways I can verify it.
Tell the court.
One is which I have my passport here, dated in customs when I hit the United States on the 30th. And I also I went and took a cab to my house and then immediately dropped off my baggage, got in a car, Jen and I went down to her apartment complex and called the police from the parking lot. We have an event number. We were not able to find that, but the police does have record of it that night.
Okay. And so she knew as of October 30th that you weren't Brussels because you came to her house, correct?
I brought the police to her house with an event number.
At that date, did Amy hand over the children?
No.
Okay. Was it your custodial day when you arrived there?
I believe I had the time. I'm not 100%.
Would you take the police to her house with your minute order during a day that she's awarded custody?
If that date was on anything other than every other weekend on Saturday and Sunday, so I believe that was on a Thursday, October 30th.
Okay.
Wasn't Halloween on a Friday, the 31st, so it had to have been a 30th, the Thursday.
Okay. And that was your custodial day under the orders?
Yes.
Okay. And isn't it true that you received... Okay, tell the court what you did approximately 10 days prior to your trip to Spain, what you wrote to Amy explaining to her position about your trip and who would care for the children. Tell the court in your own words.
I informed her that I had a nanny that was going to take the kids, and I wasn't needing her service. And I was aware at that time that I do not have to do first right of refusal. And I also said that, I realized the mistake in what I did because you're not supposed to receive overnight visits. That was told by the court.
Okay. And do you recall asking Amy to provide an order where she was allowed to write a first refusal? Your Honor,
I don't remember that, no.
Your Honor, I would move to have this marked as an impeaching exhibit on this issue because you asked us to come up.
You're impeaching your own client?
Yeah. I'm asking to have this marked or allow him to refresh his recollection of what he wrote on October 17th.
I stopped my cross-examination of this guy because I was not allowed to go to my book to pull out all the evidence I have. If she's allowed to approach him, then this is a mess. Because I was told that we can't use anything for anything if it wasn't produced as an exhibit. I even know
To refresh.
I can.
Use it to refresh.
No, I think this is backdoor. I'm going to sustain the objection.
Okay, then for the record, Your Honor, I would stipulate to the admission, I think it might have been already, of my client's response to his request to produce and first set of interrogatories. That's 52 and 53. Because, Your Honor, we did respond and say that it's too burdensome to provide all of them, but both of them have notice of all the emails exchanged since July 19th.
Counsel, what
Your Honor,
I
for the
told
record, this is an
Mr.
evidentiary
Mullins
issue.
will apply to you equally. Anything that was not exchanged before a deadline as a prospective exhibit or witness is not coming in absent compelling cause.
Don't you
and
want
I
the
do
truth
not
in the
find
emails?
compelling cause at this
Well, the
point.
compelling cause is to get the truth, Your Honor, that who's telling the
Counsel.
truth on deprivation of visitation, because it's one of
You
the
know what?
factors.
You know what? Trials are about truth-telling, but trials are also about rules.
Okay, fine, Your Honor. If you're finding that we have not responded to the discovery appropriately, that she had it at her
The word
access?
wasn't discovery counsel.
All she's
The
saying
word
is that in a
was, my
response to a
order
request for
was
her to...
documents
That's what I'm
were
saying.
to produce by a certain deadline that were going to be potential exhibits at the time of trial. That is the rule. That actually isn't 16.2. Would you like me to give you the site? It is 16.2. Oh, God. Subpart.
She's on notice, Your Honor.
5, subpart A, or excuse me, subpart A and B.
But I want to make sure we're clear. I did produce the documents I was trying to produce.
You know
I just
what?
didn't
You
put
know-
them in an exhibit book.
Objection.
But I gave
I
them to
would
her,
move to
I
strike.
indexed them to her, I bait stamped them, and I handed them to her. What she's doing
I'll
now
withdraw
is she's
the
trying to get
When?
in... What she's trying to do now...
I just told her she can't do it,
Okay,
so,
that's fine. Fair.
and I'm going to apply this equally to both of you.
Do you recall the timing of when you wrote Amy clarifying what you believed were the clear court orders? Do you remember the date? In
October
October.
17th.
Okay. What
The
time?
morning of October 17th.
How early?
I don't
What
remember the
time did the
exact
kids
time.
go to school?
8.
Was it before they went to school or just after, or when? Do you remember?
I don't remember. I dropped the kids off at 6:30
Okay.
in the morning.
Okay. So then what happened?
Or no, I'm sorry.
but
They
what-
weren't at school.
What happened was, during the day on October 17th, did Amy like your response about not having right of first refusal?
No.
Okay, what did
She
she
didn't
do
like
in
it.
return to
She
your letter?
took the kids
What
on
time? What's your understanding
During
of
school.
how she got the children from school? Withdraw. Did the school have a copy of the minute order that declared what days she was to receive them?
Objection, speculation.
No.
Okay. As of the date she took the children on October 17th,
I'm going to, at this point, consider it's already answered. There's no point in striking. Go ahead.
did Amy give you any notice that she was taking any of the custody back of the children before October 17th?
No.
And when did she finally let you know she was taking custody back?
October 17th, in an email at 2:24 p.m., which is approximately 10 or so minutes after school session is out. And it's about a 2-page document, which means it was premeditated. You can't just type all that right away. I mean,
Hey, was your understanding that the children remained in school until the bell rang on October 17th?
I don't recall that. I'm sorry.
And did Amy tell you in this letter that you said you received after school on October 17th, did Amy ever tell you, well, 90 days are up? Or did she tell you a different reason why she was taking the children?
She said that the 90-day stipulation was up.
And what else
And
did she tell
July
you?
19th to October 17th, if you count the days, is 100% exactly 90 days.
Did you write her back and say you're wrong, that wasn't temporary? Did you write her back and try and reason with her?
Yes, I did.
And what was her response?
You're going to need a pickup order. That's all I really
Did she
remember.
offer that you... did you attempt to go get the children by a police assistance?
I went completely nuts. I was totally helpless. I pleaded with the school. I knew something was going to happen before October. When I showed up and dropped off the kids at school on October 17th in the morning, I told the school administrators, Teresa Riddle up there and her staff, that my ex was becoming increasingly erratic through communication on email, and that I thought that she was going to take the kids while I went to Spain, or remove the kids or something like that. I also told the kids' daycare, kids, that Devin went to in the morning, that I was concerned about her behavior and concerned that she was going to take the kids as well, too.
I'm going to ask you if you, as of October 17th, did you have any drug test results that were ordered on July 19th from Amy? Yes or no?
No.
Okay. Did that concern you?
Yes.
Okay. And did you make, but besides bringing the police, did you make other written requests to Amy to please let you at least see the children?
I did.
What'd you do?
I asked for at least visitation
And what'd she
during
say?
that time. No, she refused unless I got therapy, and she made up a whole bunch of things that I had, hoops that I have to go through. Totally unfair.
What else did she do besides file? Isn't it true that, right, she said you were going to be receiving motions that she's filing with the court, correct?
She said that I was going to be receiving motions and that I was going to get prosecuted criminally. I guess she said that during that time that she had Metro on me. And they did, in fact, contact me, and they found nothing. And she also, during that time, from October 17th till November 5th, when I received the children back, I'm sorry, I forgot where I was going with this.
What else she did during that period with the legal system?
Oh, she filed for a, how do you say it, recluse of the judge? What do you call it?
Recusal?
Recusal of the judge, and also a motion to set aside. And she even bragged in an email that I couldn't do anything about it because Judge Togliatti doesn't come back until December 11th to sign a pickup order. So, and that proved to be kind of a problem because I brought the police to her house 2 times before Spain, 2 times after Spain, and the police actually asked me to stop coming to the house and trying to get the kids back. They said it was a civil matter. They said there was nothing I could do until I had a signed and raised seal on the decree. So we had to do a bifurcated, am I saying that right, decree. And then I brought that November 3rd, which is, remember I tried to get the kids on October 30th. When I stepped off the plane, I went to try to get the kids. She refused. And then November 3rd, I ended up getting the decree, I think that day or the day before, whatever it was. So I ended up bringing the police to November 3rd to go pick up the kids, and I had my decree with the raised seal, and they tried to get the kids, and then they came back, 2 cops, and they told me that I could not get the
Objection,
kids.
hearsay.
I have event numbers.
After speaking to the police, were they able to exchange the children peacefully for you?
No, because
No?
at that time they said that
You
Objection.
can't say what
Hearsay.
they said.
I'm sorry?
You can't say what they said. It's hearsay.
Okay.
But based upon what they said, did you leave with the kids?
No, I was requested that the signed and raised seal decree was
Objection,
not
hearsay.
enough, that I needed a pickup order in order to
Question
do that.
hearsay.
Your
When I object, you got to
Honor,
wait
and
for
it's
the judge.
stricken.
Your Honor,
Make a
I
ruling.
asked him what his understanding was. He said his understanding is he had to get a civil pickup
Except
order.
that he said they said because of what they told him.
So, when you left there, your understanding was that a raised seal on a decree without a civil pickup order was not going to be enough for the police to help you, correct?
Correct,
So
yes.
what was your next step was to do what? Did you make other legal attempts to peacefully exchange the children?
Yes.
What did you do?
The next day on November 4th, I went to the Henderson Police Department on the other side of Green Valley, 215 on the south side of it.
Is that where
Yeah.
Amy was living at that time?
She lived on Green Valley, yeah, more towards the south area.
Okay.
Yeah, off of Green Valley Parkway was her address.
Okay.
So I went to the precinct or whatever that was over that. Anyways, I spoke to the sergeant there, and the sergeant actually called her and spoke to her on the phone. We have event numbers on this as well. And
Objection, foundation. He's testifying to things about whether someone else called someone, and there's no foundation laid to how he would know. And if he does know, it would be by
Standing there.
hearsay.
He said he
Well,
was.
then ask him how he knows that.
He said, I'm
It's the
standing
same.
at the police station, Your Honor, and I was standing there, and the sergeant picked up the phone and called her. He observed it.
Say
You can
he
say
saw
that. You're saying it for the first time, which is evidence, and it's not proper.
if you ask me, I can tell you what happened.
Okay. Tell the court if you observed anybody at the police station in Henderson on November 4th trying to assist you in receiving the children. Yes or no?
Yes.
What did you observe?
The sergeant came out. I told my story. The sergeant then went into the back room, then came back out and said that I just called Amy and spoke to her about the children.
It's not offered for the truth, Your Honor. It's offered to prove his impression
This
and
is
state of
continued
mind.
hearsay, and my objection stays the
It's
same.
not offered for truth of the matter. It's what he believed was going on. So it's not hearsay.
It's being offered for
It's
the
his
truth.
intent and his
It's
peaceful
hearsay.
intent. Oh, really? So your belief when you left the police station on Wednesday is that there was still nothing the police could do to help you, correct?
Correct.
Okay. So they've admitted into evidence against our objection initially the letter number 54, the letter dated November 5, 2013 from my office. Do you remember me the next day? You said, Patricia, I'm going to need your help again. Will you write a letter?
Yes.
Okay. And isn't it true that we made, in that exhibit that she submitted as evidence, we've made additional efforts to get her to have her HIPAA authorization done, her drug test, and to return the children to you peacefully?
Yes.
Okay. Now, after we sent that letter in the morning of November 5th, what happened in the afternoon of November 5th, 2013?
She sent an email telling me to come and pick up the boys, and then an hour or a half an hour, I forget which it was, after that, she sent another email saying that she doesn't agree with the findings, but she is forced to hand over the kids to me or something.
Isn't at this time didn't she have an application for a temporary protective order pending against you, waiting to be heard in December?
Yes, but I did not find out about that until November 4th when I was in front of the sergeant at the Green Valley Parkway location.
So she filed an application for temporary protective order on behalf of herself and the children, correct?
Correct.
And she, after filing that, she, the next day, handed the children over to you, correct?
Correct.
Okay. Now, what happened when we appeared in December of 2013 before Judge Bill Potter, the hearing master, at that TPO application hearing on Amy's TPO application?
Amy didn't show up.
Okay, and what happened in that case? What did the judge order regarding your request for attorney's fees for that action?
I forget, he did award us attorney fees.
But who was going to decide the amount of fees?
The judge.
He said that to bring it before this
Right.
court. And you requested those fees in your motion filed in February of 2014? Las Now, isn't it true also that as of November 5, 2013, the Las Vegas Metropolitan Police Department Sexual Assault Unit was still interviewing...
Objection leading.
Sustained.
Was anyone interviewing you on or about, still, in November 5, 2013, about allegations Amy made about you and the children?
I don't know if it was November 5th, but yes, I was contacted by Metro's sexual abuse department or whatever. A woman, I just can't recall the date. It was in November, though. She was inside my house as well.
Who was inside of your house?
The Metro abuse investigator. She came over and met with myself and the kids. She sat right in my living room.
Isn't it true that... isn't it true that you received a letter stating that... what was the result of the investigation that Amy instigated with the Metropolitan Police Department in...
They said that...
Salvation.
Sustained.
Did you ever get any writing from the Las Vegas Metropolitan Police Department about the allegations made by her in or about October and November 2013?
Yes.
And what did you receive?
I received a letter saying that they're not investigating me, that it was over, and there was nothing there to go forward with, or something like that, some summation of it.
Okay. And tell the court how, during that period, between October 17th and November 5, 2014, how many...
13.
Just
13.
and December... No.
Okay.
Between the time when she took the kids on October 17...
2013.
I'm sorry, 2013, and November 5, 2013, have you gone back and computed how many custodial days, court-ordered, you lost by her helping herself to custody? Yes or no?
I have.
How many days did you not receive custody of the children that you were ordered to receive? 14
days in total.
And I want you on this subject again. Did there come a time when you believe Amy, again, unlawfully took custody of the children after that period?
Yes, on March 4th of 2014, and she was sanctioned by the court.
For that?
March 4th, for that occurrence, from March 4th to March 25th, I believe it was.
How many custodial days, under the correct custodial order, how many custodial days ordered did Amy help herself to during the March 2014 month?
15.
So how many days total since the last custody order was made do you believe that Amy deprived you of court-ordered
I'm going to object.
custody? How many days?
I'm going to object to this.
What's the
because
objection, one word?
The objection is it's misstating the record. There was a temporary set-aside of the order. There was a set-aside of the
I
order.
didn't tell you could go any further than Ms. Vaccarino is correct. And I am going to sustain the objection on that basis. I do believe it misstates the record. Rephrase your question, counsel.
How many court-ordered custodial days in March 2014 do you think you lost by whatever Amy did or believed?
Objection? She did so by a valid court order.
Your Honor,
How can she?
you can object to the form of the question. There's nothing wrong with the question, but he's...
The form of the objection is improper. It's one word. If I want more, because I don't understand the one word, then I may ask for it. If I think I need an offer...
Characterization of the record. Mischaracterization.
Overruled.
15. 15 days.
Did you carefully go back and calculate the days you believed you were deprived of custodial time with your children?
Yes.
And the total is... from that
14
date
plus 15,
is
29
equal-
days.
Thank you. Now, the period Amy is alleged in her motion, I don't think she said it in her testimony, but that she lost 14 days, 8 a.m. to 9 p.m. of custodial time with the children between November 5th and December 11th.
That's what she alleges, correct?
Do you agree with that
Yes.
number? Yeah, okay. Now, do you believe that you made a... Were you in bad faith in holding on to the children, in your opinion, until Judge Togliatti signed that order on December 11th?
No.
Tell the court why and explain what your thinking is during that period.
The court needs to understand that those boys were not going to school.
For how many days during when she
Well,
had them between...
that's the funny thing about it, is October 17th to November 5th, there's actually a 3-week period there. But during that time, the school had a number of teacher education days or whatever where school was out. So to answer your question, a total of 9 days they were out of school. But it happened over a 3-week period with lots of off days in between and stuff like that. So it's unfortunate that number is so low as to 9, but we were waiting to get to 10 before we could get truancy involved in that sort of thing anyways, because I was mind-boggled that the kids were not going to school. And she tried to get them registered into Bartlett or something like that in Green Valley. She tried to register the kids over there, and they refused, and they sent her back to Judas Steele, and Judas Steele, the administration staff, refused to release the kids because they didn't know what was going on.
Okay.
It was a complete mess.
So,
Totally
Are you
helpless.
telling the court you contacted Child Protective Services or any other authority about the 9 absences?
I did.
And you
I
received...
requested for them to make a home visit and try to get the kids back as well. I try to use every resource available to me to get
And
those
you're
kids.
saying that you learned that they can't do anything until 10 days are reached?
Objection leading.
No, I'm just... all right.
That is leading.
Okay. Your understanding was CPS could not become involved until when?
10 days after they missed school.
Isn't it true that you, in my office, advised Amy of this concern, as included in the letter admitted as Exhibit 54?
Objection leading.
Overruled.
Isn't it true that these concerns with the school issue, et cetera, were mentioned to Amy and her maybe attorney at that time?
Can I see 54 before I say yes? This only goes up to 53, and this starts at 58.
Okay. I mean, actually, this letter provides a laundry list of your concerns as of that date. Is that true?
Yes,
54?
this is your letter to her. Is it okay to refer to this?
Is it true?
Evidence, yes.
Is it true that you've clearly laid out what your concerns were with all the stuff that Amy had been doing?
Yes, we laid out a whole bunch of stuff.
And as of November 5th, Amy didn't file an emergency motion for custody.
No. She went right for the recluse of the judge.
Now,
All right.
refusal.
Yeah, I can't say that word.
So, in court on December 17th, Judge Nathan asked us why we didn't file an emergency motion.
Objection.
Do you recall?
This
Judge-
gentleman wasn't present at the hearing.
Sustained.
I can use it in closing, Your Honor. It's in their brief. That's fine. So, did you feel like any harm could come to your children if you just handed them over after November 5th to Amy? Yes or no?
Yes.
Okay, tell the court what kind of concerns you had if you just handed them back over to the person that just took them and deprived you of 14 days of custodial time. Tell the court what your concerns were.
I was made very clear by the office at CPS that if those
Objection,
kids...
hearsay.
Why you had, you're not, I don't want you to tell us what CPS said, but after they told you why you were concerned.
I'm sorry, rephrase
What,
it.
just
I'm sorry.
tell the court what your concern is. You learned some of the concern through CPS, correct?
Yes.
Tell the court why you were concerned with just willy-nilly handing the children back off to her until you could get a civil pickup order.
Because the kids had not been going to school, and they need to be going to school every day.
Especially which child, in your opinion?
All of them.
Well, Daniel has Asperger's, correct?
Yeah, he needs the structure every day, and he was pulled out of my house into a whole different schedule and a structure with no structure because he wasn't even going to school. Obviously, that was a big concern, but it was all of them. I couldn't imagine that being them walking out and getting dragged out of school when she did that and having to go through what they did, and all of a sudden they're in a household that is secure and steady and always there into an apartment with some boyfriend that she just got and no structure, no going to school. It was mind-boggling that nobody could help me.
Okay. And so, what was your biggest concern that could happen if you ignored your concerns and just handed them back over to Amy? Tell us what the concerns were.
I don't even want to go there.
You need to explain
I was
to the
concerned.
court.
I'm concerned for their safety. I'm concerned about them getting, I don't know if ejected from
Weren't they
school.
being interviewed right now by weren't police officers interviewing them about issues?
She
from the
claimed
Okay.
that people were interviewing her.
It's also
them.
she made a demand that she wanted to take one or all of the boys to counseling. Correct?
Objection leading.
Sustained.
Tell the court. Do you believe you would have adequately protected your children's welfare if you just handed the children back over after November 5th without strict court orders? And was it
I
not...
have to have an audible answer to the question.
No.
Okay. And did you receive information that would cause you that you could possibly again have a charge of CPS against you if you did hand them over?
I was very, very nervous of that.
Why?
Because I can be held responsible if those kids do not make it to school, truancy, that sort of thing. There was so many concerns. They had dentist appointments. I remember at the time, Danny had a huge cavity, and her taking the kids, they missed their appointment as well. And I sent her emails saying that, the kid needed to go to the dentist, and he had a huge cavity, and it was not addressed at all.
Isn't it true that one of the allegations Amy made against you on October 17th that you were committing serious educational neglect of your children?
On what date?
I'm sorry, October 17th when she first took the children in that email. Didn't she tell you that one of the things she was concerned about, that you were educationally neglecting the children?
Yeah, and
Okay,
financial abuse and everything else she's been trying to nail me on for years.
Okay, and tell the court, as of that first 3 months of school that year, 2013, how were your boys performing?
They were performing excellent. I had no indication that anything was going wrong with them. Homework was going good. We had a kindergartner, we had a first grader, and we had a second grader. And everybody was doing their homework. Report cards were coming in good. Nothing was indicating that they were in bad shape or anything like that.
Tell the children, tell the court what kind of awards your kids were receiving when you were exercising pretty much sole custody during the school week. except for
My oldest, Dylan, received the spelling bee award. He won the spelling bee on his first grade.
How old was he? Oh, so you're about 6?
Six or seven, something like that. And then my kindergartner, or I'm sorry, and my kindergarten. No, hold on. First grader Danny. If I'm messing up, I'm sorry. Danny was also selected to the finals of the spelling bee as well too. He lost in the finals, so he actually semifinals, I guess, is where he was at. But Devin was only in kindergarten, so they don't do spelling bees and stuff like that. So the kids were doing amazing, just like they are right now. They're all A's and B's.
Well, isn't it true that they're doing amazing, but Daniel specifically, this school year, since the custodial order was changed last July, is having some behavioral issues at school?
He is.
Okay, and tell the court, have any of your children, first and foremost, let me back that up. When Amy testified on December 22nd, she testified that she found out that Daniel spit in a child's face at school, correct? Yes or no?
Yes.
Okay. Did you find out the same information the week before, just before trial last time?
Yes.
Okay. What did you do when you found out from the school that your son, Daniel, spit in another boy's face? Did you...
I sent an email to her right away, notifying her of it.
Did Amy notify you in response of what she had learned?
No.
Okay. Did she...
She often ignores stuff, though.
So, tell the court, Daniel is in what grade this year?
Second grade.
Okay. And last year in first grade, with the Asperger syndrome, tell the court what grades he earned for his final grades at the end of the year.
I'm not 100% on that. I know he was, to make it general, A's and B's.
Okay. Any C's on the final report card?
I don't remember. I cannot recall. I'm
On
sorry.
final report. Okay. Now, tell the court about how many times your son was tardy during the year that you had, the time that you had sole custody.
0.
Okay? And tell the court if your son, Daniel, during the 2013-14 school year, if he had been suspended from school.
No. No.
Did he ever spit in a child's face?
No.
Did he have any other serious behavioral issues reported that required consequence by the principal?
He did have one outburst in a restroom. He was, I guess, crawling underneath a stall or whatever and scared, I guess, the kid taking a crap or whatever, and they made a big thing about it. But it wasn't like it wasn't anything like what's been blowing up. No.
Okay. And so, what do you believe currently with Daniel, because of his Asperger's? How is he coping with this litigation that's not ending? In your opinion, as his
Foundation.
Sustained.
do you have any opinion of whether or not your children are affected by this ongoing divorce litigation? Yes or
Objection,
no? Do you have an
Foundation.
opinion?
Sustained.
If he's not allowed to give his opinion?
He can
Gotta
give
say
reasons.
facts.
Do you agree with the judge's opinion on what, as she stated in March, April, and July of 2014, of what can happen to children in ongoing bad custody cases? Yes or no?
Yes.
What did you learn from this judge, in March and April of 2014 about what would be best for these children as of that date? What did you learn?
We were admonished by the court to put our differences aside because it's all about the kids, and we have 3 beautiful young boys. The last thing we need to be doing is in here arguing when we need to be there caring for them. And she admonished us, I'm sorry to interrupt,
Go ahead.
that we were going to have a problem child on our case, and she's seen it a million times before, and that's the road that we're going down. And honestly, I thought that we'd be seeing that maybe in future, but we're starting to see remnants of it now. Daniel needs to be in a structured home. He cannot be bounced back and forth. And I say that because he needs to have stability. That's the way he thinks. He thrives on it.
And your testimony is that you believe you were providing that when you had the timeshare that was agreed upon on July 19, 2013.
Yes, I've lived in the same home the entire time I've had custody of the children.
Compare that to Amy since July of 2013.
5 different homes in
She's
under a
moved
year.
5 times. Okay, are you sure about the 5 times? Because Amy's sitting here and saying no while you're testifying. Is it 4 or 5 days? 4 or 5 homes?
I'm going to object on foundation.
I know I can definitively say 4 homes.
Oh, no, I think I want the foundation. I want to know from when.
I can give you 4 addresses right
Okay, go
now.
ahead. Tell us the first address.
No, you're going to give me foundation from when to when.
Okay. Since July 19, 2013.
So that's not a year.
Since July.
2013 is about a year.
Okay.
July-
During 2014, how many times do you believe Amy moved?
1, 2, 3 times.
Okay. And did she move this year yet?
Not that I know of.
Did she move between July 19 of 2013 and December of 2014?
Yes.
I'm sorry, 2013.
Yes.
How many times, to your knowledge, did she move?
Twice.
And you say you've lived in the same place?
Yes.
Okay. And tell the court for us, I want you to go back and compare the 2012-2013 school year. But you had 2 boys in school. Daniel was pre-kindergarten, correct? I mean, Devin.
Pre-K and a first grader with Dylan.
I'm sorry, Devin's the youngest.
Devin was not out of school. He was in her care. We tried to do daycare, but she refused to do that. Whatever.
So in 2012, when the divorce was pending before Judge Giuliani,
Yes.
initially Mom had more custodial time, correct?
He had primary custody.
Okay, and tell the court, have you reviewed the school records from that school year, 2000?
Yes.
Tell the court how many times on Amy's watch during her custodial days were the children tardy to school?
Daniel and Dylan, my oldest, and Daniel in pre-K were both tardy 52 times. Now, the interesting thing about that is her house is about 100 yards away from the school.
Back then.
Back then, yes.
And tell the court, was the 2 oldest boys' performance better in 2012, 2013, when she had more custodial time, or worse than the next year when you had more custodial time?
It's much better now.
No, I'm asking you from 2012-13 to the year when you had the majority of the time, 2013, 2014.
The kids have been doing consistently better in school, especially by viewing the grades, than they did in the 2013-14 year than the 2012 year that she had
Okay.
custodial right or whatever.
So now tell the court, for this year's school performance, are they doing, all 3 of them, as well as last year, 2013-14, or not as well?
They're doing as well. We have 2 of my kids on A and B right now. On A and B honor roll,
And who's the one that's not on AB honor
Danny.
roll?
Daniel.
Was Daniel on AB honor roll last year when you had almost sole custody?
Yes.
So,
I'm going to, I have a question. Did custody change? My understanding is they've been under the same custody order since July 19, 2013. So I'm confused here where he's saying.
John, I'm going to object. He can bring this up on cross, I guess.
This-
or review.
Do this on cross.
Now, let's talk about your Amy has testified about your son. She's filed a motion that's still pending to want your son, Daniel. He's your oldest. He's
No, Danny is our middle
Oh, sorry,
one.
your middle. Dylan's oldest.
Dylan's
Daniel's
oldest.
the one that's been diagnosed with Asperger's through the school district, correct?
Yes.
Okay. And Amy, in her motion, her that she filed, has attached emails where she's referred you to certain links that you should read to discuss how to handle Daniel, correct?
Yes.
Okay. Have you taken her advice and read those websites?
I have read the websites
Now-
extensively.
Did you find that some of the mistakes Amy has made have been not helpful to Daniel's autism over the last year?
Protection Foundation, and there's no evidence of what yet.
Well, I'm asking for it. Did you
I'm
find?
not sure that this isn't asking for a medical opinion.
I'm asking what he's done and what he, this was where we're going with
But you're
this.
asking him for an opinion
That's
as to
not
what
what she
he's
did.
done and what she's done and whether or not it's appropriate.
Let me
in
make
that.
this clear. She wrote him and said, and she testified on December 22nd, we have an Asperger's kid at Autism Special Needs. You have to handle him a certain way, and I've tried to tell Michael that. His testimony today is, I have listened to her, I have read it, and in my opinion, the advice she's giving me, she's not taking for herself.
She's testifying.
Wait a
All I
minute.
objected to was when he said,
I'm done.
do you have evidence
Ron, I
that Amy
can't
did
finish.
something
It's
wrong?
unfair.
No, I'm just, Patricia, I had a simple question about foundation, about what you know, what he knows about this. You can get it in, just ask her the foundational questions.
Just ask the foundational question.
The question was foundational. Where did you get some of your information on Asperger's from? Did someone refer you to some websites? Yes
Yes,
or no? Who
yes.
referred you to the websites?
She did.
Okay. Did you read the websites?
Yes.
Did it sink in of what you're doing with your son and what you're not doing with your son that has Asperger's?
No,
Did you understand the information you read?
I did.
Do you believe that? What do you believe? The advice that Amy referred you to. One of them was, oh, I don't have it in front of me, but it's in her motion that was filed. Do you remember going to autism fieldwork? She referred you there.
I
Yes
do.
or no? Okay. And didn't you read that there are techniques to use with a child with Asperger's to help manage his behavior?
That was about autism, not Asperger's.
Well, there were. Did you read any articles specific for Asperger's?
I did.
Okay. And do you believe that, based upon the website she referred you to, that you are properly tending to your son's condition?
100%.
Okay. And tell the court what are some of your concerns that Amy has done that's not conducive to behavior modification for your son?
Objection, foundation. It's the same question.
I'm asking you what she did over the last year.
You asked what she did. I want to know how he knows. That's all.
And
Have you had the opportunity to observe actions that Amy has taken since July 19, 2013, in relation to your children and your custodial time? Yes or no?
Yes.
And in your opinion, have you been treated fairly or properly by Amy, that's supposed to co-parent with you? Yes or no?
No.
Okay. And do you currently trust Amy is telling the truth to the court?
No,
Okay.
I don't.
Okay. And do you believe that you have adequately addressed any of her alleged concerns about Daniel's Asperger's?
Yes, 100%.
And in your opinion, have you witnessed any conduct by Amy since July 19th that doesn't help your son, any of your sons, but specifically Daniel with Asperger's?
Yes.
Like what?
Specifically, she directs me to these autism sites, and they're like for full-on autistic kids. Like, none of the stuff that is listed in that website or in the links that she has provided me even match up to him. Danny is a sweet young boy. Let's not forget he's only 7 years old, by the way. The light is on in his head. All his IEPs, everything have been brilliant.
Let's talk about the IPs, because you both have marked them as exhibits. Has your son met standards or not? Or exceeded standards in the IEP?
Exceeded standards. He is reading way beyond his level. His math is way beyond his level.
Okay, let's talk about the math. Amy testified that she believes your son's math level is at a 47? What's your understanding at the parent-teacher conference? What did you learn about your son's math?
And that's the thing that she didn't testify correctly about.
Why?
Because that was a number that was given when the kids were first tested when they entered the grade. And she was at this parent-teacher conference in December before this trial, where she was told by the teacher in the teacher conference meeting that this was Danny's first score, but this is what he's reading or what he's doing at math now. I'm sorry I don't remember that number, but that number is exponentially higher than the first number. And she also did that with the other kids as well, too, trying to make me look like I'm not going through their homework and all that stuff when the kids are doing fabulous. And it shows improvement from the beginning of the year, before they had any instruction, fresh out of summer, to where they are now. And she conveniently left that part out, which the court has to take into consideration.
Okay, I'm going to show you what's been marked as exhibits double E and double F. You can stipulate to these, because I know you have some crossing the same.
Double E and double F.
I gotta use the bathroom.
Okay.
Gotta go quicker.
It's just so much.
Where's the exhibit? Are they the same ones that I admitted, or are these different ones?
I think you have.
We have not admitted these. We did not admit double E.
I'm going to object because they're not produced and discovered.
They were produced, Your Honor.
No, they were not.
There were no. I received no documents from her before discovery closed.
Your Honor.
The double F was. the
Nevertheless,
double E
it's their
was not.
grades. You can't deny
Double
that.
F was, you're saying,
Guess
because
what?
I know it's crossover.
I think they've been
Just double
produced,
F.
and I do think there's compelling cause for the court to look at it, because I'm interested in the best interest. So assuming that they are the children's performance records, I'm going to allow them in.
Then I don't need any further testimony on that, because the court can take the time. My client says he has to take a potty break. Will you allow that, so you can take a look at
Let's
it?
take a
I got to do
10-minute
that too.
break.
I just didn't want to interrupt.
And this would be a good time, RC, because I know you like to look at documents. Go ahead.
Am I good?
Yes, you may. Thank you, Your Honor.